Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions of lemonade. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Michigas. Ridiculous that insanus. Oy vey, Marcus. Pro said, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
We're back. And while I was trying to have a break, like 5 more things broke and popped off. So there's a couple of things we got to cover first before we jump into AIDAN Kearney's motion to dismiss. How's everybody today? Today's Friday, July 10th, 2026. It's a twofer Friday today. It's a twofer Friday. I'm trying to figure out exactly what this is. This new procedural order that Judge Belezos just released today having to do with AIDAN Kearney. There's a whole bunch of things here. Let me just see something. July 20th. Is that the date? That is the date of the mega motion. All right, help me decipher this, if you will, because I know many of you can help me. It's hard to do things live on the fly because I prefer to read stuff and then digest it, but it never happens that way. So it just never does because things are breaking constantly in all of these cases. How's everybody doing today? If you missed it this morning, well, I don't know where our badass affirmation is. Because I have like 5 cards in front of me, and I don't know, but you guys remember what it is. My head is spinning in so many places right now. But this is what goes on. This is what goes on when you live stream because so many things are happening that you don't even know what to cover first. But first, the thing that's this was just filed at 2:18 p.m. today by Judge Belezos. This has to do with AIDAN Kearney. The other thing is an emergency motion to continue to the deposition of Proctor by Karen Reed's team. And then we can look at AIDAN Kearney's motion to dismiss because everything is always happening. It's way too much. So what you need to do, please hit the like button. I don't know, share the stream, something. It's a lot of work. It may look easy, but what happens here behind the scenes with just me is really a lot of work. It's a lot of work. First up, let's look at what Judge Belezos just released at 2:18 p.m. while we were live on the other stream. And this is in AIDAN Kearney's case, a procedural order regarding all of these papers. Number 103, 135, 139, 140, 141, and 142. And guess what Judge Belezos doesn't want? He doesn't want anybody rebroadcasting this stream on the mega motion to dismiss without special permission of the court. I'm sorry, what? You know what? And they're going to force me to open mass courts up in another tab so that we can exactly know exactly what these papers are, but I'm going to have to do that so that I'm getting it right. So hold please while I do it. Is this live? Yes, it's live. It is live. It is not Memorex. It is live. It is live stream number 2 for the day. This is in, well, it's in Suffolk County, but originally wasn't this in Norfolk County? So won't the docket be under Norfolk County? Who knows at this point? Who knows? Hold on. 2382. CR 00313. Let's see. Yep. But the caption on this one says Suffolk because that's where this judge is sitting, but that is not the accurate caption. All right, so I'm gonna go over here for a second. This over here. And here's what it says. This is a procedural order regarding all of these filings in the AIDAN Commonwealth versus AIDAN Kearney's criminal case. Okay. Criminal case. We've been following this one too. So this is the criminal case. So paper number 103, I got to scroll all the way down to find it. So give me a second. This is the motion, the mega motion. Okay. Paper number 103 is the mega motion to dismiss the criminal charges against AIDAN Kearney. Judge's order today says, on the 20th of July, 2026, the court will hear argument in room 808 of the Suffolk Superior Court. Okay, so if anybody wants to go, that's where you're going. That's where you're going. Room 808 of the Suffolk Superior Court. It's like downtown Boston. I hear it's a pain in the ass to park there, and it's really expensive. But if you want to go support the mega motion, because I don't know if we're going to be able to broadcast it, the hearing will begin promptly at 9 a.m. As the matter has been fully briefed and largely consists of grand jury material familiar to the court. Each side will be limited to 30 minutes of oral argument. Really? 30-minute limit? A 30-minute limit? How long did it take us to cover that mega motion? How long? How many streams? 20 hours or something? Maybe 20 hours? Hold please. Got my throat coat tea because, I need it. If anybody has never tried throat coat tea, it's amazing. It's hot tea. It's great for your throat. Coats your throat. You guys tell me about it. Hold, please. Okay. Following arguments, and then it says paper 135. Following arguments on paper 103, the court will address the third party's motion to intervene. Oh, really? We motion to intervene, you say? What's that? Let's see. Paper number 135. Oh, that's the O'Keefe family's motion to intervene for limited purpose of facilitating enforcement of a civil subpoena. So the O'Keefe family wants to intervene in AIDAN Kearney's criminal case to get a full copy of his phone extraction. Okay. So following the arguments on paper, the mega motion, the court will address the third party's motion to intervene. If either the Commonwealth or the defendant wishes to file written opposition, it must be filed no later than 1 p.m. on Friday, July 17th. So that's a week from today. Such opposition may not exceed 7 pages. It must be provided to the third party at the time of filing. Okay, so the 20th is going to be the Monday. They have until that Friday to file that. Then paper number 139. Allowed, however, the defendant, including agents and/or counsel, is ordered to refrain from disseminating any materials, including correspondence provided by the Commonwealth and/or the taint team, until the parties have had an opportunity to address the issue on July 20th. All right, so paper number 139 is allowed. Let me just go back and see what that is. I think 139 is who the hell knows? It's not even on here. 139. That says 139, right? I don't see. Oh, here it is. 139 is the Commonwealth's motion to authorize the clerk's office to transmit to council a copy of the special master's report. So I guess the special master's report is the taint team. Okay, so that's allowed. But nobody is allowed to disseminate anything provided by the Commonwealth or taint team until the parties have had an opportunity to address the issue on July 20th. Okay. Cool, cool. Paper number 140 is denied as written. Well, what's 140? So you have to have 14 screens open and look up everything because the judge doesn't want to tell you what they are. Defendant's motion to impound unredacted copies of supplemental motion to dismiss affidavits and exhibits. So the motion to impound 140 is denied. However, the court will order paper 141 and any supporting exhibits impounded. All right, so 141 is defendant's second motion to compel. That's disclosure of Michael Proctor's communications with incorporated memorandum. We went over that recently. That was filed on June 23rd. So that's going to be impounded. And paper number 141 and 142. 141 is the defendant's second motion to compel disclosure of Michael Proctor's communications. And defendant's updated motion to compel so everything has to do with Michael Proctor's communications. All right, so 141 and 142. If the Commonwealth intends to oppose the defendant's request, they have until 1 p.m. on Friday, July 17th, 2026 to file their opposition. Such opposition may not exceed 20 pages. Well, here's the thing. Commonwealth in this case is Cosgrove, right? And so Cosgrove doesn't seem to think that any of the rules apply to him, so he just never responds to anything. And that's just the way he does it. So the court has to put like a hard stop on him, like actually. All right. Sorry, I was distracted by something. The Commonwealth, the judge has to put a date that Kazi G has to respond by because he doesn't seem to ever want to respond to anything ever. I don't even know that he's responded to the mega motion yet, right? Cosgrove limited to half an hour. I know. And then look, it says, be advised, the hearing will be available by Zoom. However, recording and or rebroadcast, okay? And or rebroadcast is not permitted without first seeking leave of the court pursuant to SJC Rule 119. I'm sorry, what? They know how much public interest is involved with the persecution of AIDAN KEARNEY, and they are now going to prevent anybody from rebroadcasting this hearing? So you have to be a member of the media to rebroadcast the hearing? You know how we usually rebroadcast mainstream media or Law and Crime or Court TV, and that's perfectly acceptable because we're legal commentators and we change it up. I just don't like rebroadcast Law and Crime on my channel with me not even being on the stream. Some people do that, and that's not proper. And a lot of channels who do that get stricken or will get stricken. But it's called fair use when you commentate. They're not going to be able to handle the Zoom. The Zoom will not be able to accommodate all of the people. It's not like that. You can't just apply for a media LLC. It's not the way it works there. Sounds like it. I'm not doing that. I don't know what this means. I don't like it. It sounds like they're trying to hide it and they don't want anybody talking about it. But that's insane. XOXO, Judge Belezos, July 10th, 2026. That was just today. That means you can't rebroadcast it. That means that even if you're not live streaming it, you can't rebroadcast this conference at any time unless he's just talking about the Zoom feed and you can rebroadcast like mainstream media feed. I don't know, but I don't like it. I don't like it. Yeah, I mean, certain people have media, like Grant has a media pass, but I don't know. I don't know if he'll have to be there. Yeah, but here's the thing: Trial Channel will have it for us afterwards. This is rebroadcasting. This is referring to rebroadcasting. So it would hit them. It would hit anybody else who rebroadcasts it afterwards. I don't know if this has to do with only the Zoom. Some mainstream media is going to need to move for clarification on this because where's freedom of the press? Right? Classy Cupcakes. I think that's insane. He's preventing Turtleboy from doing a rebroadcast. That could be, but it seems to apply to everyone equally. You tell me how you read that. Who's gonna? Lever Robin says that signature is criminal. Nothing to see here. No recording either. Nothing to see here. Nobody wants anybody to see what's happening to AIDAN KEARNEY. The world is watching. I know you are because a lot of you are here from outside the U.S. We'll have to figure that out because it's not until July 20th. It's 10 days from today. But I want to know what that means. Okay. Okay. Right. Attorneys can't talk about it either. Nobody can talk about it. It sounds like a gag order, but it's not really. So like he wants 4,000 people. I've got 4,300 people here with hardly any notice. You want, and I had, what do we have this morning? I don't know. 9,000. We're almost at 10,000 at one point. You want 10,000 people on your Zoom feed? What you wish for. I can't understand why every reporter in the Commonwealth of Massachusetts is not all over AIDAN's case because it involves journalists. It involves trying to silence journalists and prevent them from reporting on stuff. And I don't understand why every single reporter in the Commonwealth of Massachusetts is not out there screaming about this. Do they not care about their own rights? This is, yeah, because they're scared. They're scared that it's going to happen to them. KB in Virginia, so much for transparency and justice. And everyone has been waiting months to hear this argument. Yep. When was that original mega motion filed? 103. I'll tell you when. Hold on. Originally filed September 23rd of 2025. It has been almost a year since that mega motion was filed. I know that it had to be adjourned a couple of times because of emergencies with AIDAN's team and other things. Why is not every single reporter up in arms about this? This man was thrown in jail for 60 days, okay? Based on what I think is a fake subpoena served upon Lindsay Gattani. Like, this is insane. I've seen Christina Rex go knocking on doors, haven't you? And that's unfortunate, right? And is that the difference? Fairy tale nails by Joe. And mainstream media do not see AIDAN as a serious journalist. They see him as a blogger. He's a great journalist. First of all, I don't know when like blogger became like so derogatory. That's the way they want to make it sound. He's been doing journalism for 10 years before he ever even heard the name Karen Read. He's been exposing corruption for 10 years. New media is now the media. I hate to break it to them, but nobody's watching, the 5 o'clock news anymore. They're just not on regular TV. People are not, that's not where they're getting their news. Why do you think that? Everybody, Chris Cuomo, everybody is starting a YouTube, Ashley Banfield, they all have YouTube channels now because that's what people are watching, YouTube. Who's watching the 5 o'clock news? Who's watching News Nation on their television? Who's even got cable anymore? I mean, I do because I'm old school. I have cable, but nobody's watching it. And they know it. And so they're all coming to YouTube now and trying to build their platforms. Vinny too, Vinny, all of them. Brian Enton, yep, everybody. And so nobody wants you to see this. And that is an abomination. The Goodmans say, you're our 5 o'clock news, right? Billy Bush, Megyn Kelly. Every single one of them used to be mainstream media, and every single one of them is coming to YouTube now. And you should be outraged. DirecTV just filed for bankruptcy because everyone's moving to other sources. Oh, interesting. Interesting. Aidan has Aidan has a media pass, but he would have to get special permission because look, you have to get special permission from the court. You think they're going to give it to anybody? I don't know. Well, that's the way we started off the stream, to learn that we're not going to likely be able to broadcast or rebroadcast Aidan's mega motion. We'll have to figure something out in the meantime. That's the first thing we're covering. The second thing, 20 minutes in, is the emergency motion by Karen Reed's team to get Proctor's deposition. That was filed. Well, it says it was filed on the 8th. Today's the 10th, and it just hit the docket. So was it just unsealed? I don't know. Let's take a look. This is a cold read. Haven't read it yet. This is in the O'Keefe versus Reed case, the wrongful death case, the car accident that didn't happen, the case that we just watched a hearing on earlier today. Emergency motion by Karen Reed for reconsideration of the order delaying the deposition of Michael Proctor. I told you this was going to be a problem. Defending Karen Reed, because remember the judge said a motion to clarify is not the proper way to do this. So here's a motion to reconsider. Karen Reed respectfully requests the court reconsider its June 29th order staying further discovery of Michael Proctor. The court stated on the record that it had stayed the second day of Proctor's deposition because an attorney with an appearance in this case had violated either the letter or the spirit of the rule. That statement is incorrect. First, the ex post that the court cited as the only evidence that its impoundment order had been violated was actually posted before Proctor's relevant June 8th, 2026 filing. Second, the information that the court claimed had been disclosed by an attorney was already public as of June 6, 2026 at the latest, more than 2 days before the filing or impoundment of the order at issue. Footnote 1, which reads, Reed's counsel was prepared to present the evidence presented here at the July 1st in-person hearing, right? When the judge ran off the bench and wouldn't hear anybody. However, after delivering its prepared remarks, it was scripted. It was scripted. The court left the bench and refused to allow any party to be heard. Oh, tell it. Tell it. Print that. They had it ready. They were ready to argue it. They weren't allowed to because he ran away. Run away, run away, run away. Thus, the foundation upon which the court relied to suspend Proctor's deposition was mistaken, and the court should vacate its order to avoid unnecessary delay in discovery, particularly where the second day of Proctor's deposition is already scheduled for July 14th, which is next week. Next Tuesday, as a matter of fact. Footnote 2, which reads, Reed brings this motion on an emergency basis because the second day of Proctor's deposition is already scheduled for July 14th, and all counsel and parties have already planned for that date. It is particularly important to protect this scheduled date because Proctor previously asserted that he had limited availability. It would be unduly and unnecessarily costly and burdensome to force Reed to miss a previously scheduled deposition day because of this order, which was based on an incorrect premise. Were Reed to serve this motion via Rule 9A, the oppositions would not be due until after that currently scheduled date. So, when they file motions via Rule A, That's when the entire package is collected and then submitted to the court. I'm reading between the lines here, and although I'm not a Massachusetts barred attorney, I imagine that if you make an emergency motion, you can file it with the court directly, immediately, without waiting for any response. And that's why they're doing it this way, because the oppositions wouldn't be due till after the deposition on July 14th. Oh, please. Reed's counsel did confer with Proctor's counsel concerning this motion prior to filing it. The post in question was created at 10:52 Eastern time. That didn't get by any of you. All of you caught that. The court stated at a hearing that it was staying further discovery of Proctor because Proctor's counsel, we know now it was Proctor's counsel who sent the tweet. Proctor's counsel sent certain impounded pleadings and exhibits to the court and counsel at 2:22 p.m. on June 8th, and that the ex post in question was created exactly 30 minutes after the email to counsel of record and contained information similar to the information contained in Proctor's filing. That is incorrect. As the court can see below, the ex post in question, which was provided to the court by Proctor's counsel, Proctor's attorney is the one who sent this ex post to the court in a letter that prompted the court's June 30th order, was created at 10:52 a.m. Eastern time. Hold on for 1 second. Hold, please. Okay. The image provided by Proctor's counsel had a 2:52 p.m. timestamp. However, that is because it was apparently accessed by a user without an X account, which defaults the time zone to Coordinated Universal Time, UTC, 4 hours ahead of Eastern Time. See this hyperlink with time zones. When accessed by a user with an account set to Eastern Time, the post appears as follows. And it's a tweet by AIDAN KEARNEY. I'm telling you, I think the judge needs to be recused from this case, because if he believed this and he believed AIDAN KEARNEY was the leak, how can he determine anything or decide anything with regard to AIDAN KEARNEY and the defamation case? And with regard to AIDAN KEARNEY being forced to produce documents, it's wild. Here it is. Here's AIDAN KEARNEY's post. And as you can see by looking at the bottom, 10:52 a.m., June 8th, 2026. That's the date, the correct timestamp on it. And I guess they're freaking out because this had 167,000 views. 167,000 people viewed that as of the time that it was printed. Here's the tweet. Michael Proctor decided to have a mental health crisis after the whole world found out how racist he is. Sources tell us he checked himself into a mental health facility in Florida to try to avoid today's deposition. They filed a motion at the last minute on Friday to delay the depo, but the judge wanted proof. They submitted an affidavit that was impounded because it likely said Proctor was in a mental hospital. Karen Reed's lawyer made the mistake of saying the scheduling of the deposition was strategic, which the judge took issue with based on her comments on the Today Show. He stayed the depo for 24 hours, and at 4:15, a hearing will be held. My guess is he's going to tell Proctor to jump on a plane and stop being such a pig so that Alan can depose him tomorrow. The message was actually posted more than 3 hours before Proctor's filing and not exactly 30 minutes after it. Therefore, it does not prove or suggest that anyone has violated the court's impoundment order. The information in the ex post the court referred to was public 2 days before Proctor's counsel filed or served the pleadings and exhibits the court relied on to justify its order. On June 6th, the ex-user the court referred to on July 1st held a live stream on YouTube. We've played it several times. It was Turtleboy. It was Turtleboy's June 6th live show, Saturday Live, during which he stated that he had received the same information from a third party. That was 2 days before the impounded filing the court believes was improperly shared. That YouTube clip is contained on the USB drive attached as Exhibit 1. The following posts also predate the June 8th impounded filing, also show that the information in question was public prior to that filing. Footnote 3. Reed is mindful of the court's prior statement to counsel that social media posts are not evidence. However, they are relevant here because the court expressly relied on social media posts as justification for its order. And this is a post by KY Maverick. Which do you believe will most likely happen Monday? Poll ends before Monday hearing. Turtleboy is live. Says Sherry Thompson, the court. This is like the same motion we read the other day. Are we sure that this is new? Was the motion the other day a motion to clarify, and now this is a motion to reconsider? So here's the Sherry Thompson tweet. And then Petty Boop's tweet. I'm sorry, but if Proctor's in a hospital in Florida, did they not know this before the close of business on Friday? Yeah, where is Kyle? Because Kyle's the one who sent this to me, and this is the only thing that was on the docket. Hold on. I don't know. There's too many things flying through the chat. Kyle, email me because I don't know if this is the same thing that we're talking about the same thing here. We got that. I mean, it's got the same caption. I think the other one was a motion to clarify. Yeah, that's what you sent me. Okay, so this must be different, right? I don't know. In any event, let's keep going. The court's remedy for what it incorrectly determined was a violation of its impoundment order has primarily impacted Reed, who's the party who subpoenaed Proctor, began taking his deposition, scheduled a second day of testimony, and has spent significant resources compelling in taking his testimony. Additionally, despite the fact that there's no evidence of any violation of the court's impoundment order, Reed has, as the court instructed, made a proposal to all parties concerning an order she would agree to propose to the court concerning deponent's medical information. No other party has responded to Reed's proposal. This comes on the heels of Reed earlier proposing to all counsel that witnesses' testimony in transcript, audio, or video form only be used for the ongoing litigation and not otherwise disseminated. As Reed indicated previously, the plaintiffs have never responded to that proposal or multiple follow-ups. Under these circumstances, and to prevent further prejudice to Reed, the court should reconsider its order, vacate it, and permit Reed to proceed with Proctor's deposition on July 14th. Wherefore, defendant Karen Reed respectfully requests that the court reconsider its June 30th, 2026 order and vacate its stay of discovery from Michael Proctor. It was filed on the 8th, but it didn't hit the docket until today. Sent to just about everybody, including Proctor's attorney. When will they hear this? I don't know. All of this is getting very conflated and very confusing, and it's insane. Why is everyone protecting Michael Proctor? Feels like everyone is protecting Michael Proctor. Doesn't it? Is it just me? Do you see it too? All right, moving on. Who knows what the judge will do with that? Because at this point, we are so far into the twilight zone that I'm really every day I just wonder where we are. Where are we? we just sat in on a conference on the motion to compel. This was not discussed at all, I guess, because Proctor's attorney wasn't told to be there today. We do know that Tully and Higgins depositions both did happen this week. And the 14th is this Tuesday. There's a bunch of stuff happening on the 14th. All right, let's get into AIDAN KEARNEY's motion to dismiss. Here we are, 35 minutes in. All right, I'll write it down. 35, 15. Because they're all racist, Jack says. Hold on. Okay, so yesterday we covered Karen Reed's motion to dismiss the defamation case. Today, we're going to turn to AIDAN KEARNEY's motion to dismiss the defamation case. They both have different arguments. I mean, similar arguments, but obviously they're not represented by the same attorney the way that all of the Haas defendants are. And we're going to read most of it, maybe not every single word of it. Pertinent parts. I haven't read it yet. So again, cold read, settle in. If you don't like my voice reading to you, then you're free to leave. You don't need to announce your departure. It's not an airport. Oh, please. Overruled. Sit down, says Cosgrove. Can't talk that fast. Classic Cupcake says, okay, it's me, Cupcakes for Justice. Tin, hopefully I'm back. I think you're back. I don't know. I don't know what happened with the usernames. They have ats in front of them. I don't know. I don't know what happened. I saw people like complaining about it before, but I don't really know what happened. Does it make you easier? Does it make it easier for you to tag people in the chat? I don't know. John Doe wants to know if crossbody bags are allowed for me. I prefer a briefcase, but if you want to wear a crossbody briefcase, that's cool. I just don't think that lawyers who are, in their 40s and 50s should be lugging backpacks around. I just think it looks unprofessional. Dish is preparing for bankruptcy, not DirecTV. Thank you, John Doe, for pointing out all the things. I appreciate you so much. Overruled sit down says maybe Turtleboy needs to stand on a box in Times Square like the founding fathers. Well, maybe it should be in Boston somewhere. Craft Haskell said Turtleboy did a members only this morning. It was a history lesson wrapped up in a modern day scenario of his life. So glad I got to see it. Turtleboy's right. Thank you for tuning in from across the pond. Sue says I was driving for the last hearing and I laughed so hard I choked on my water. Oh man, I hope you're okay. Home safe and sound now. Happy Friday. Happy Friday, Sue. Thank you. 30 months. You're an OG. Aura says that 2 years we've been together. I love it. I love you with all of my heart too. All right, let's get into reading this. Otherwise, we're going to be here all night. I work in investment banking and everyone uses backpack now, but you're not going to court. You're not going to court. You also don't wear suits and ties anymore, right? Okay. Lawyers are the last people, I think, the last profession to wear a suit and tie. And I just think, in my opinion, a backpack looks stupid with a suit and tie. I mean, fight me on it. You can disagree with me. I don't care. I just think it's my personal preference is all. That's all. I know. You also have you can wear golf shirts to work now in investment banking, right? You guys aren't wearing suits and ties anymore. What's the thing? I don't know. I think it looks silly. All right. Sorry if that offended you. No offense meant. All right. I really like this legal writing. I just want to see who wrote it. Because I know that Betero is also on the defamation team now. And so I think, this feels like Betero's writing to me. It just feels like it. StreamYard's been a little glitchy, so we're just going to have to deal with it. It is signed by, Jeffrey Pyle served it. And he also signed it, but it's got Mark Betero's name on it too, so I don't know. All right. The backpack discussion is over for now. Okay, here we go. It's my personal opinion. You can feel free to disagree. Here we go. This is AIDAN KEARNEY's memorandum of law. This is where all the meat is. This is where all the meat is. So there is a notice of motion, which is like 2 pages long. That's really nothing. This is the memo of the law. This is where the meat is, and settle in because it's like a nice story. It's a nice story. So maybe Pyle did write this, and if he did, good job. We're used to Mark Bettero's excellent storytelling. This is defendant AIDAN KEARNEY's memorandum of law in support of his special motion to dismiss plaintiff's first amended complaint pursuant to the Anti-Slapp law, General Law 231, Section 59H. And they did make a motion to file a 31-page memorandum, which was granted in June. The motion for reconsideration regarding Proctor has been denied already. I mean, the news is breaking so fast that we can't even cover it. But you know who must be refreshing the docket all day long? Kyle Sharkey. Kyle Sharkey's out there doing the Lord's work. So if it comes from you, I know that it's true. And sadly, I just closed. Oh, wait, no, I didn't. I can just what if I just refresh it? Okay, so that emergency motion that we just read to reconsider the staying of the deposition of Michael Proctor, according to Kyle Sharkey, has been denied. And that means that Proctor's deposition part 2 will not take place on Tuesday. Why is everyone protecting Michael Proctor? Go off on it in the chat. Go off on it in the chat. And when I read, like when I'm reading, I usually don't watch the chat. So I'm glad that I saw that so that I could report that to you as well. What in the actual fresh hell? This is why, you know, we have props. We got a rubber duck. Remember the rubber duck? Investigation better than the investigation into the murder of John O'Keefe. You got this? Something's going on here. It runs deep. It runs deep. And now everybody knows it. And now everybody knows that what AIDAN posted about Michael Proctor is true. Welcome to the Afro Man effect. All right. Try and save your questions because I'm not going to be looking at the chat while I'm reading this. I'll take breaks every, I don't know how many pages. And I'll try not to interrupt it too much unless I have really something important to say. Introduction. 3 years ago, defendant AIDAN KEARNEY, an independent journalist and online content creator, began writing articles, publishing videos, and leading protest activity over the prosecution of Karen Reed for murder. Convinced that Reed had been framed for killing her boyfriend, Boston police officer John O'Keefe, KEARNEY enlisted members of the public to demand that the charges be dismissed, that responsible law enforcement officials be held accountable, and that the Commonwealth instead charge plaintiffs Brian Albert, Jennifer McCabe, Colin Albert, and Brian Higgins with crimes relating to O'Keefe's death. KEARNEY's brash mix of activism, advocacy, and investigative reporting brought national attention to this little-noticed case, leading to the remarkable Free Karen Reed movement. With KEARNEY's encouragement, hundreds participated in daily courthouse protests, engaged in public advocacy, and advocated for reform. And look, they're citing the amended complaint, praise be. KEARNEY's relentless activism made it impossible for people to not know about the case. And it's true. When have you ever seen this before? In a case involving someone who is not a celebrity, you may never see it again, or you may actually, because so many of you have written to me and said, I never even followed court cases before until I started listening to what was going on with Karen Reed and what was happening to Karen Reed. And now I'm obsessed with justice. So many of you have said that to me, that you never even followed this stuff before. And now you can't stop. And that is one of the great things about you. Just one of the great things about you. And we'll see. We'll see what happens if this happens again. I've never seen anything like it before. Plaintiffs have now sued KEARNEY for his speech and activism around the O'Keefe killing in the Karen Reed case. The legislature, however, has enacted very broad protection for petitioning activities like KEARNEY's. The Anti-Slapp law grants civil immunity for the exercise of the right to petition the government. its protection extends not only to statements made directly to government bodies, but those made in connection with ongoing judicial proceedings and statements reasonably likely to enlist public participation to affect governmental consideration. I mean, this is a good argument because this is exactly what he was doing, trying to mobilize the public to educate them about what was happening to Karen Read in his home state of Massachusetts. The anti-Slapp statute immunizes this broad category of conduct from suit except where it is devoid of any reasonable factual support or any arguable basis in law. As explained below, the anti-Slapp law requires dismissal of all of plaintiff's claims against Kearney because they are based solely on his petitioning activity, and plaintiffs cannot prove by a preponderance of the evidence that his petitioning was devoid of any reasonable factual support or arguable basis in law. Factual background. The following facts are drawn from the allegations in plaintiff's amended complaint and the affidavits and exhibits filed therewith. Footnote 1. Each of the exhibits referred to in this motion is attached to the affidavit of Jeffrey Pyle, so he did draft it. I'm enjoying it so far. How about you? Unlike a motion to dismiss for failure to state a claim under Rule 12b-6, a court faced with an anti-Slapp motion shall consider supporting and opposing affidavits stating the facts upon which the liability or defense is based. A. AIDAN Kearney's investigative reporting and video streaming content. AIDAN Kearney is a writer, investigative reporter, and video content producer known as Turtleboy. For the last 13 years, he has published a widely read website currently titled TB Daily News. He also publishes live streamed video content. Some of Kearney's best known work has involved police misconduct. In October 2017, for example, Kearney was the first to report that state police officials had ordered a state trooper to omit incriminating information about the daughter of a district court judge from an official arrest report. Exhibit 1, Phil Demers, Worcester DA's office, state police communicated about scrubbed arrest report of judge's daughter in 2017, noting that Kearney's blog, then called Turtleboy Sports, was the blog that broke the story of the altered report. This is what he does. This is what he does. Kearney's reporting resulted in the resignation of State Police Colonel Richard McKeon and Deputy Superintendent Francis Hughes. The State Ethics Commission later found reasonable cause to believe that the Worcester DA Joseph Early Jr. and other officials had violated the conflict of interest law in their handling of the police report. Wow. So what you're saying is AIDAN Kearney has been hated by district attorneys and police officials since at least 2017. Oh, I see. I see where this is going. Footnote 2. The Ethics Committee's petition did not result in a finding of a violation. That is also hyperlinked. Separately, Kearney broke the story that State Trooper Leah Genduso had been hired by the MSP despite having previously participated in a marijuana trafficking operation, and that she may not have disclosed that information on her application. She's out there now, has joined the band of the antis, and really hates AIDAN Kearney because I guess he got her fired by breaking that story. Pyle Affidavit Exhibit 2, Paul Tuthill Scandal, Scar, Massachusetts State Police, WAMC, Northeast Public Radio, March 23rd, 2018, noting that the blog Turtleboy Sports reported that years before she was hired, Genduso had been charged in a massive federal drug investigation. She escaped prosecution by agreeing to testify against co-conspirators. See how deep this runs? Kearney's website and videos comprise a mixture of investigative reporting, analysis, opinion, and the kind of vituperative, abusive, and inexact language that is a hallmark of political speech under the First Amendment. Footnote 3. See generally, tbdailynews.com and YouTube. So see generally his entire website and his entire YouTube channel. He's hyperbolic He can be, he can say a lot of words that I don't like, and he can say a lot of things that I don't like. The problem is for them that he's got the right to say those things. That's why there's the First Amendment. You may not like his style or his content, but he's got the right to say what and he's uncovered other scandals before. Because he comes with receipts. No wonder they're so afraid of him. Like many other media outlets, TV Daily News features advertising. Kearney also requests donations and sells merchandise to support his work. Yeah, big deal. It's called, making a living. B, Kearney publishes articles and videos about the Karen Read case. Plaintiffs allege that in April of 2023, Kearney began receiving information through an intermediary from Karen Read, the defendant in a pending murder case in Norfolk Superior Court. Read had been charged with killing her boyfriend, Boston police officer John O'Keefe, by backing her car into him outside the Canton home of Boston police officer Brian Albert during the early morning hours of January 29th of 2022. On April 12th, 2023, Read filed a discovery motion to obtain Mr. Albert's phone for analysis, meaning Brian Albert's, not Colin Albert's. The motion attached numerous documents, including police reports. On April 18th, 2023, Kearney published a blog post about the Read case headlined, Canton Cover-Up Part 1. Corrupt state trooper helps Boston cop cover murder of fellow officer, frame innocent girlfriend. That was part 1. How many parts is it up to now? Only tell me if you really know the real answer. People think that. Grant Smith Ellis has been doing a deep dive into this about the human trafficking, aka Epstein connection between officials in Massachusetts. I haven't had a chance to watch it, but he's been diving into it really deeply. So I'm going to recommend to you the Towel News Network if you want to know about that. A Lie Unchecked Becomes the Truth. It is Grant Smith Ellis on YouTube. That's the name of his channel. He is known as the Towel News Network, which is a nod to South Park. I don't know. You can't try and stop the chat about telling me to look at something in the chat because it gets me sidetracked and I'm trying to focus on what I'm doing right now. So I can't do that. Sorry, but I can't have to keep just my focus. Okay. How many parts is he up to now? 4,227,000. A lot. I mean, there's 6,000 people here chatting, so it's a little bit difficult to do that. Grant's reporting on the alleged networks with Jeffrey Epstein is excellent, and he's been developing the story for many months. He has absolutely dove into it. At least 553 or 552 parts he's up to, because he comes with receipts. Canton Cover-Up Part 1. Corrupt state trooper helps Boston cop cover up murder of fellow officer, frame innocent girlfriend. The post is 70 pages long. He does his homework, including photographs obtained through Kearney's reporting efforts and screenshots from court pleadings and exhibits. Contrary to plaintiff's allegations, Kearney wrote the post himself. Its content was not funneled by Read to Kearney. I think AIDAN would let anybody write his content. He's a good writer. And he comes with receipts and he does his homework. And he's got people calling him because they'd rather call him to report to him than the police, because they know they can't trust the police there because this has been going on for decades. Ask anyone who lives there. In his Part 1 post, Kearney sets forth the Commonwealth's theory of the O'Keefe killing and the evidence supporting it alongside information from the defense's discovery motion. Based on his assessment of the evidence, Kearney concludes O'Keefe was violently beaten to death by persons inside the Brian Albert's house, who then hatched an elaborate plot to frame Read for killing him. Yes, he's an excellent history buff because he was a history teacher. He was a high school history teacher. He knows a lot about history, and it's very interesting, the things that he teaches me sometimes when I'm watching. History repeats itself, right? As evidence, Kearney cites to damning facts set forth in the defense motion for discovery. These include that Brian Albert's sister-in-law, Jennifer McCabe, who was present at Albert's house, had searched Haas Long to die in cold at 2:27 a.m. on the night O'Keefe died, long before O'Keefe's body was discovered at 6 that morning. Kearney reported that McCabe had taken steps to purge her phone of this inculpatory search and to delete her communications with Brian Albert. O'Keefe's phone, Kearney noted, had tracked him walking up and down stairs between 12:20 to 12:32 a.m., movement that would have been impossible if he was inside Karen Reed's car or lying on the ground outside of the house, as the Commonwealth alleged. Kearney also reported that in the morning after Canton police arrived, Brian Albert, a veteran Boston police officer and trained first responder, didn't even come outside, despite the fact that a crime scene was unfolding on his property. Point me to one thing in that paragraph that is false. Because there's evidence of all of it. I told you from the beginning that Karen Reed's trial was going to be a battle of the experts, and it was. And in the end, the jury believed the experts of the defense. Kearney argues in part one that the killing was the subject of a cover-up, aided and abetted by members of the Massachusetts State Police, the Canton Police Department, and Norfolk County DA's office. The person most responsible for the cover-up, Kearney stated, was Massachusetts State Police Trooper Michael Proctor, who failed to speak to key witnesses and never applied for geofence data that would show the identities of every person in the house that night. No lies detected. Kearney then makes a direct plea for government action. Trooper Proctor, Brian Albert, Colin Albert, and Jennifer McCabe should all spend significant amount of time in jail, and 2 of them should be charged with murder. The Canton police chief and deputy chief should be fired. Every other person in that house should be charged with obstruction of justice, as they witnessed a crime and never reported it. Following his part one post, Kearney wrote many more articles about the Reed case in which he argued forcefully for her innocence. On April 18th, 2023, he published part 2 of his Canton cover-up series, in which he responds to commenters who had criticized his earlier post. In part 3, published on April 20th, 2023, Kearney criticizes the Norfolk DA, Michael Morrissey. The post is titled, "Norfolk County DA says he will continue prosecution of innocent woman Karen Reed." Morrissey, Kearney writes, knows full well that Karen Reed did not kill John O'Keefe, but he's pushing forward anyway for one reason: pride. He's not man enough to admit that his office is complicit in covering up for a murder. Every minute wasted on the prosecution of Karen Reed is time, money, and resources that could be spent investigating and charging the people who killed John O'Keefe. It is an absolute joke and a disgrace that this politically connected hack of a DA is pursuing this. He should resign immediately and hand over this case to a competent individual. Kearney then calls on his readers to email Michael Morrissey at state.ma.us. Here's what I'm going to make a suggestion, because there's a lot of people who are like, I don't like AIDAN Kearney. I don't like the way he talks. I don't like the words that he uses. I don't like the names that he calls people. I'm going to suggest to those people, and to all of you really, go read his articles. Go onto his website and just read his articles instead of listening to him, and tell me if you have a different opinion about what he's saying, because he's not, he doesn't have that personality and the language that you might not want to watch. Because what we're reading here in his writing is very different from his live streaming, right? It's very different. And I don't like the way he talks all the time. I don't like the words that he uses. I don't use them on my channel, but he's got the right to say them. And I suggest that if you don't like watching him, go read his articles and tell me if it gives you a different vibe. Okay, Crime Sleuth, and I'm not putting that up on the screen because I cannot vet it. Okay, so please do not post anything in my chat about where Michael Proctor has been, because I am not going to get busted or my channel demonetized because people in the chat want to out Michael Proctor and where he is and where he's been. Please don't do that. Okay? I don't know if you know it, but there's a lot of YouTube channels getting stricken out there for doing stuff like that. So just please don't do it. He's been disparaging Michael Marcy. He's been disparaging public officials. He's broken many scandals. And he's a guy. This is one of the ways that we are alike. When something bothers us and it has to do with justice and we feel very strongly about it, we don't shut up. We keep talking. We use different words, but we keep talking. They've tried to shut him up. They put him in jail for 60 days. They've tried to shut me up too, in many ways that I will not talk about on a live stream. I was in Michael Marcy's emails, for God's sakes. Somebody suggesting that I should be charged with RICO. And Michael Marcy took that email in November of whenever that was, 2024, and forwarded on to Brian Tully and Hank Brennan. That gives me pause, and it's frightening. It's ridiculous, but the fact that Michael Marcy would forward that on to Brian Tully, some people will be scared away from talking about stuff like this. Some people get louder, and when they get louder and you're over the target, that is when they come for you. That is when they come for you. Like Socrates said, hold on. When the debate is lost, slander becomes the tool of the loser. When the debate is lost, slander becomes the tool of the loser. You know it. I know it. We all know it. Socrates knew it too. And there's Moulin Rouge just because I love Moulin Rouge. All right. Back to it. He's not, and he's talking about Michael Marcy. Wait, where were we? We were here at Michael Marcy's email address. These posts mark the beginning of Kearney's years-long and ongoing campaign of investigation, advocacy, and petitioning surrounding the Karen Read case. The amended complaint alleges that Kearney has published 550 parts to his Canton cover-up series to date, as well as thousands of tweets, hundreds of blog posts, hundreds of YouTube videos, and countless other public statements across a variety of platforms. Kearney's petitioning spawns the Free Karen Read movement. This is number 3. I just made an executive decision, and what we're going to do is we're going to cover the motion to dismiss tonight, and then we're going to cover the opposition in a different stream. We're going to break it up so that we can talk about it more without having to jump to the opposition right away. You know what I'm saying? Okay. Plaintiffs admit, as they must, that Kearney successfully encouraged thousands of people to join in his efforts to ensure justice in the Karen Read case and accountability for John O'Keefe's killing. For example, on July 22nd, 2023, Kearney assembled at least 200 individuals to participate in a rolling rally through Canton, focused on the case, culminating in a protest at the Canton Police Department. After 500 people joined Kearney at a protest in front of the courthouse on July 25th of 2023, he published an article exhorting his readers to continue to speak out. Soon, Karen Read, this is a quote, soon Karen Read will be a household name across the country, and we are responsible for that. It has put public pressure on the DA's office and Judge Cannoni to remind them that there are millions of us watching their every move. We will not allow them to frame and prosecute an innocent woman for murder while her killer remains free. We will continue to make our voices heard until there is real justice for John O'Keefe. Kearney undisputedly inspired hundreds of people to protest in front of the courthouse every day during Read's 2 trials. The amended complaint, paragraph 106, alleging, in words of protester, that, quote, Turtleboy was the reason there were people outside the courthouse every single day chanting Free Karen Read and wearing pink as a symbol of their support. During Read's second trial, he drew protesters from as far as California and Georgia, and they stopped to take pictures with him. That also comes from the complaint. And they're admitting every single one of those things. They're like, yep, yeah, he did it. He absolutely did it. Turtleboy was the reason. Yep, you're right about that. We're not gonna dispute that. We admit it. After Reed was found not guilty, Kearney stated that he would like to think that some of the evidence that was presented to the jury in court was a result of his journalism and his influence and his activism online. Kearney also applauded himself for conducting standouts, putting up billboards all over Norfolk County for Free Karen Reed and making it impossible for people not to know about the case. Observers of the trial shared plaintiff's assessment of Kearney's central importance in driving public discourse about the Karen Reed case. See Exhibit 7, written by a guy named Brad. Turtleboy factor. As Karen Reed trial starts, Holden bloggers' influence on display. That was published in the Worcester Telegram, April 16th, 2024. Parens. While the murder allegedly occurred in Canton, the publicity that has turned it into a regional and national fixation largely stemmed from the blog of Holden's AIDAN Kearney. Yes, in fact, his name Turtleboy comes from a statue of a little boy and a turtle that is in like a Worcester public square of some kind. He named himself, he took his name from a statue in Worcester. Did he grow up there? I think he did. Exhibit 8, Catherine Elton wrote, Free Karen Reed blogger Turtleboy will not go quietly. Oh, I just lost my earbud. Hold on. My in-ear monitor. That was a Boston Magazine article from May 19th of 2024. Parens. Almost single-handedly, through relentless blogging and YouTube streaming, Kearney upturned public perception of what seemed like an open and shut case, casting a thick cloud of doubt on the workings of our justice and law enforcement systems. Exhibit 9, Chris Heath wrote an article, Turtleboy will not be stopped, in The Atlantic on March 10th, 2025. Parens. There's a solid argument that the whole public discourse around the trial, not just the heightened interest in it, but the galvanizing of a small movement of people committed to defending Reed against what they believed was an imminent injustice, was catalyzed mainly by Kearney's interventions. Participants in the Free Karen Reed protests agree. Exhibit 10, affidavit of Rita Lombardi. Oh, look at that. And Exhibit 11, affidavit of Paul Cristoforo. They wrote affidavits in support of AIDAN Kearney. I love that. I didn't know it. I didn't know it. I love it so much. Oh, that like makes me very choked up because Rita Lombardi has taken a step back from that whole thing. And here she is coming out in support of AIDAN. Were you surprised by that? I didn't know. This is a cold read for me. I can't read. I'm not in law school anymore, so I don't read hundreds of pages every night. I love it. That's amazing. Kearney's writings, this is number 4. Kearney's writings, and I love this. I love this because you know what? He's not denying any of it. He's owning it. He's owning it. He's like, yeah, I did all this. And you know what? All of these people who are, just more than bloggers, all of these esteemed reporters from, the Worcester Telegram, Boston Magazine, The Atlantic, have all written articles about me and how this is true. And I started a movement. Number 4, Kearney's writings. Cristoforo is even a bigger deal. Somebody said Paul Cristoforo was mad at him. I'm not even sure. I don't even know the lore behind that. We do love Rita. Love Rita. The 2 most real OGs, says Risa B. I love it. For those of you who know the lore, you know more lore than I do. Kearney's writings lead to a Canton special town meeting and an audit of the Canton Police Department. That's right. Sue knows. Sue says Rita is the best and she gives great hugs. Kearney's language. Aidan's language isn't always professional, says user number something. You're right. You're right. It's not. But in his writing, it's very different. And that's why I direct you to his writing to read his articles because it's very different than his live streams. He's passionate about what he does. Kearney's activism did not just inspire protests, it encouraged Canton residents to propose vote for and implement a measure to bring increased oversight to the Canton Police Department. In direct response to Kearney's coverage, residents began to speak up at meetings of the Canton Select Board to raise questions about the honesty and professionalism of the Canton Police Department and to question the actions of Select Board member Chris Albert, the brother of Brian Albert, citing Rita Lombardi's affidavit. Before its meeting on September 26, 2023, the Select Board suspended the open comment portion of future meetings to allow emotions to cool. Spectators showed up anyway, some with tape over their mouths and others with signs reading "Justice for John and Karen" and "Stopped Corrupt Officers." Footnote 4. And isn't this exactly what petitioning activity is? Footnote 4. On October 27th, 2023, in response to the criticism fomented by Kearney's reporting, the Canton Select Board announced that it would conduct 2 reviews of the Canton Police Department's operations, one examining the department's policies and procedures, the other auditing its evidence room. According to the Canton Citizen, both reviews have been the subject of numerous resident requests at Select Board meetings following the death of former Boston police officer John O'Keefe. Exhibit 13. A Select Board member stated at the meeting, "We have heard the individual concerns of our residents." I mean, and it's wild because, as we know, or maybe you don't know what I'm telling you, thank you, Scott. There are good cops and there are bad cops. Scott is one of the good ones, 25 years on the job with NYPD. And so just like there are good lawyers and bad lawyers, good priests and bad priests, we cannot lump all cops into one basket. Please don't do it. Scott will time you out. He takes it personally. And I back up my mods 100%. Nobody hates a bad cop more than a good cop. I back the blue 100%. Cops in my family. What's wild is that the Canton Select Board is the boss of the Canton PD. Chris Albert didn't run for the Canton Select Board until, remind me, April of 2023, which is also wild because the Select Board, because Chris Albert is the brother of Brian Albert, and they have another brother named Kevin who is a detective with the Canton PD. That's the dude who lost his badge and gun when he went out drinking with Michael Proctor down the Cape. Thank you for your service, Scott. We love you. He ran earlier. He was elected in April 2020. Oh, thank you, Sus. She's always helping me with the facts. Lily Lime says, I know plenty of great cops in Norfolk County, Dedham cops especially. How about the cops that tried to help Katie McLean? Do you guys remember where was that? I think she lived in Brookline. That was in the Harry Turk trial. Those cops were amazing. Like they drove her down to the police station to help her to get a restraining order against Harry Turk because he had been beating her. There are lots of good ones. In the fall of 2023, Canton residents placed an article on the warrant at a special town meeting to conduct an independent audit of the Canton Town Police. Co-sponsor Rita Lombardi states in her affidavit that she was spurred to take action to propose the audit because of Kearney's reporting. They lived in Dover. Okay, I was thinking to somebody else in Brookline. It was Dover PD. Wasn't it Dover PD? There was a really nice officer who followed Katie McLean down into the place where she had to file for the restraining order. So good. Officer Barrows is amazing. That's Dighton. I would say the good ones outnumber the bad ones. It's just the bad ones that are getting all the press right now and are making life miserable for those who live in Norfolk County and other places in Massachusetts. In an article on November 10th, Kearney encouraged every citizen of Canton to be at Canton High School on November 20th for the special town meeting. Vote yes on the audit and bring as many friends and family members with you as you can. And Kearney didn't then, doesn't now, and never has lived in Canton, right? On November 20th, 2023, the special town meeting voted 903 to 800 to approve the warrant article, despite the unanimous opposition of the select board. Footnote 5. The audit report, released in April of 2025, was a joke. Those are my words, not his. Criticized the Canton police for several failures of procedure at the O'Keefe crime scene, including the failure to photograph O'Keefe's body where it was found and to interview Jennifer McCabe and Brian Albert on camera at the Canton Police Department. The audit also criticized the Canton Police Department for leaving the crime scene unattended for 10 hours after discovering O'Keefe's body. The auditors recommended that Canton police officers undergo additional training in crime scene management and interrogation, that patrol vehicles be equipped with crime scene kits, and that policy be changed to prohibit officers from using personal phones to take crime scene photographs. A copy of the report is available here, this hyperlink. If you haven't seen it, you should, because what is wild about that audit report is that they actually said, was it Five Stones who did that report? That it was innovative. That the Canton PD used solo cups to collect blood evidence. Something like that, right? Innovative. And that it was innovative for them to use a leaf blower to blow the snow away to uncover evidence. So that was kind of wild. We have a solo cup emoji and a leaf blower emoji. If you're a new member, check them out. So many of our special emojis were made specifically for this trial. Five, each of the articles and videos identified in plaintiff's amended complaint was part of Kearney's petitioning campaign. We hyperlinked every single one, and we watched every single video in the complaint. Every single one. I don't even know how many hours. And much of it was very helpful to Aidan Kearney. In their amended complaint, plaintiffs identified 37 alleged defamatory publications that Kearney published about them, consisting of 14 written statements and 23 allegedly defamatory videos. A list of the articles and posts identified as defamatory is set forth as Exhibit 16 to the affidavit of Jeffrey Pyle, footnote 6, which reads, the list does not include every video or writing identified in the amended complaint. Plaintiffs reference some of them in an effort to show that Reed and Kearney worked together, as opposed to identifying statements that harmed the plaintiffs, right? None of them, for your information, were time-stamped. It was just the entire, sometimes 4 or 5 hour stream attached as a footnote, as an example. They were not time-stamped. They were not clipped. It was just the whole entire thing. Oh, please. The written publications that plaintiffs identify as defamatory are attached to the Pyle affidavit as Exhibit 3, 4, and 17 to 28. The videos identified as defamatory in the amended complaint total approximately 58 hours. 58 hours. Certain petitioning-related segments of these videos are summarized in a chart attached to the Pyle affidavit, Exhibit 29, which is available with hyperlinks to the videos. Oh, he did a chart. Everything. If you can, because you're able to, donate to the Aidan Kearney Defense Fund, please do. I shudder to think how much money it cost to draft this motion and to watch 58 hours of content. I think he has said, I don't know, he has spent somewhere close to maybe $1 million so far on his defense. Please, please, if you can, donate. He's also doing a golf outing. You don't even need to play golf. Go to the golf outing. Pay the money. Go. Hang out. Every dollar helps. He says lawyers were over 800,000. Yeah, and this, I can't even, I shudder to think. Lawyers bill, if you don't know, if you've never had to pay a lawyer, you're very lucky. Lawyers bill every 6 minutes, every 10th of the hour. Okay? It's a lot of money. Okay? If a lawyer bills $1,000 an hour, it's $100 every 6 minutes. And nothing ever takes less than 6 minutes. That's the minimum bill. And $1,000 an hour is cheap. Yeah, you know what? Let me, Scott, if you could, or if one of you guys, hold on. Why? What happened to my mouse? Oh, I think my mouse just died. Hold on. I got to plug it in. If somebody can link, one of the mods could link Aidan's defense fund in the chat, I will pin it. All right, there we go. It's been very expensive. I mean, it's, and you know, listen, every single journalist should be donating to too, because he's fighting for all of their rights. Thank you, Emily. It is now pinned in the chat. Thank you to Emily C. Every dollar helps. Thank you, Scott Messerschmidt. I got it. Okay, it's pinned now. Can you guys see it pinned? It should be. I did it. I think I did it. Yeah, my chat disappeared for a second, but then it came right back. Okay, smash the like button. Donate to Aidan if you can. Every dollar helps. And go sign up for the golf. If you're local, he's doing this golf outing thing. It's going to be a lot of fun. Auntie Deb is going to be there. They're going to do a show. They're going to have prizes, I'm sure. That's what golf outings do. If you're going to the golf outing, let me know. Even if you don't play golf, it's going to be fun. Oh, please. All right. You can find all the information for that over on his channel, but I did pin the defense fund. Okay? Thank you. He's fighting for all of us, for all of our freedom of speech, because they're really trying to shut us up. I mean, you hear Judge Gildea from the bench, like, court should not be a spectacle. Oh, really? Your courts have been a spectacle since they started public hangings for the witches in 1692 in Salem, sir. Runkle had a great stream about it the other day. He went, no, I think I know what it was. It was, who did the compilation video? Next Witness of the reactions. It was a reaction video. And Runkle is yelling. He's like, people used to go to court just for fun before television. It was a spectacle because that's what they did. They used to sell snacks outside, public hangings, etc. On Proctor's ledge. The witches who were convicted were actually hung on Proctor's ledge. It's real. It's true. Runkle's reaction was fantastic. Let me just make sure that I'm naming the correct creator. I think it was Next Witness, but I just want to give props to the proper person so that you can go watch it later. Some of you donate once a week. That is so nice of you. Listen, if you can't afford it, please don't. But if you have a couple of extra dollars to spare, or you can forego, you know, a latte one day, it would be a really nice thing to do. Because even if you hate his presentation and his letters, okay, it was Next Witness. Thank you. He's fighting for the rights of everyone. Okay, it's Next Witness on Next Witness channel, and it's the LawTube reaction compilation to the O'Keefe versus Reed emergency hearing. Thank you. And I love it. I love it because I love to watch other LawTubers react to stuff, to know that I'm not alone and I'm not insane and I'm not being gaslit. We're all being gaslit, but it's funny because we all covered it at the same time, and then we can go back and look at other people's reactions and we're like, oh my God, I said the same thing at the same time. I see you. What is weird now about the pinned link is it is now pinned at the bottom of your chat. So if you're looking for it, it is now pinned, if you're on your phone, at the bottom of your chat. I don't know. YouTube is making some changes. One of the other changes they're making is they're going to hike up the international pricing for membership in like August. So, but if you're a member before that, you'll get grandfathered in because of exchange rates and all of that. All of that. So I owe you. I got to tell you about. Okay. So it's on the bottom of your chat. I know some of you are like, I can't find it. I'm like, I can't either. And then I'm like, oh, it's at the bottom. Back to the documents. Each of the allegedly defamatory publications of which plaintiffs complain was part of Kearney's campaign to ensure that justice was served in the Karen Read case and to encourage the prosecution of plaintiffs for crimes related to John O'Keefe's death. They furthered those goals in several ways. One, by reviewing the evidence of Read's innocence and plaintiff's guilt in O'Keefe's killing. Two, criticizing the police and prosecution for their handling of the case. Three, calling for dishonest or corrupt police officers to be fired or prosecuted. Four, expressing opinions about the veracity and significance of trial testimony. And five, encouraging public participation in the case. Yes, he's doing a show with Jimmy that night too. Also, just, you could buy a foursome. I think he said he thinks it's not selling out because the majority of his audience is women, which is for all of us who cover true crime and LawTube, our audience is like mine, I think is 80% women. And a lot of women don't golf. I do golf. I'm not going to be there because it's not local for me. But if he's not selling tickets for just the dinner after, he should probably do that. Because I think a lot of people would come for the after party after the golf is over, which is what most golf outings do. Like you can come as a golfer or a foursome, or you can just come for the dinner after. So if he's not doing that, or you could sponsor a hole. You could sponsor a hole. So there's that. So if he hasn't opened up selling, you're part of the 20%, you are, Scott. And you thought when I started this channel, it was going to be all about makeup. And you were like, I'm not going to do this if you're just going to talk about makeup and you're going to be putting on lipstick. I don't want no part of that. So he needs to open up. I've been to many a golf outing, and there are usually tickets for the dinner or the after party. And usually they do raffles and stuff like that. So that is an idea that I have since it's already. But it's not even like a real tournament. Like it's a best ball tournament. Okay. So that means that everybody hits a ball in your foursome. You go to the furthest drive and you all go to that ball and then you all hit from there. Everybody cheats. It's like ridiculous. It's fun. But if you don't golf, you could buy a foursome and then gift it to some coworkers or some people who do, and then just go to the dinner. That's all I'm saying. That's all I'm saying. And golf outings are always fun. And Auntie Deb is going to be there. So it is guaranteed to be a really fun time. And I suggest shotgun start, best ball. It's not competitive. Even the worst day of golf is a day in nature. Okay. It's better than a day at work. It's better than a day at work. I don't know the date of it, but if anybody knows the date of it, let me know. It's really fun. All right. Karen Read's trials, number 6. The first trial in Commonwealth v. Read began on April 29th of 2024. We know we were there, and ended in a mistrial on July 1, 2024. A retrial began on April 22nd, 2025, and ended on June 18th, 2025, with a not guilty verdict on the charge of second-degree murder. At both trials, the court permitted the defense to present evidence that plaintiffs Brian Albert and Brian Higgins were third-party culprits who killed John O'Keefe. The court made these rulings after determining that Read met the evidentiary standard to mount a third-party culprit defense under Commonwealth v. Watkins argument. The Anti-Slapp law protects the right to petition the government for redress of grievances. Under General Law 231, Section 59H, wait, how did I miss footnote 7? Footnote 7 says, as of the date of this motion, plaintiffs have not complied with the court's directive to supply the allegedly defamatory videos on a thumb drive. That's not good for them. What's up, Jimbo? Why didn't you do that, Jimbo? They told you that a long time ago. Under the Anti-Slapp law, a party may file a motion to dismiss if the civil claims against it are based solely on its exercise of the constitutional right to petition. The statute provides powerful procedural protections requiring the speedy dismissal of such claims unless the targeted petitioning was devoid of any reasonable factual support or any arguable basis in law. An anti-Slapp motion is addressed in 2 stages. The first stage, the motion's proponent, here Kearney, must make a threshold showing through the pleadings and affidavits that the claims against him are based on his petitioning activities alone and have no substantial basis other than or addition to the petitioning activities. If they meet that burden, then they go to the second stage. And then at the second stage, the plaintiffs have to show that Kearney's exercise of his right of petition was devoid of any reasonable factual support or any arguable basis in law and caused actual injury to the special motion opponent. Okay, so remember who the plaintiffs are here: Jennifer McCabe, Brian Albert, Brian Higgins, and Colin Albert. Injuries can be financial, they can be emotional, they can be reputational. As far as I know, Jennifer McCabe was just a normal mom. She didn't have a job, right? She didn't work outside the home. Not saying that being a mom is not a job. It's a job. It's a very hard job. But she doesn't have any lost wages because I don't think she worked outside the home. Brian Albert, I think, retired with his full pension. So, he doesn't have any economic damages. Colin Albert joined the Army like Conrad Birdie, so he's doing fine. And he also worked at his dad's pizzeria. Brian Higgins, I'm not really sure what's going on with him, but I don't think he lost his job. I don't know. Was he rehomed? Is he still an ATF agent? Unclear. So they're going to have to show reputational damage, which means that they're going to have to show their reputations were excellent and now they're terrible. Or they're going to have to show that they've undergone severe mental health treatment and that they've been going to a psychiatrist or a psychologist and that they have PTSD or something like that, in which case all of their medical records come into play. See the difference here? When you're a plaintiff and you're claiming things like emotional damages and PTSD, let's say, or depression, anxiety, panic attacks, your medical records become discoverable because you are claiming all of these things. You have to be sure. A medical provider needs to come in and testify that because of this alleged defamation and harassment, you've suffered certain diagnoses. Karen Reed, as a defendant in the car accident case that didn't happen, is not bringing her medical condition into issue. And so her medical records should not be discoverable, or her prescription records. But we heard an argument on that today, and I have grave concerns about the way that the judge is going to rule on that, because he doesn't seem to think that fishing expeditions are relevant in civil court. And I'm here to tell you, as a civil litigator of more than 3 decades, that that is absolutely false. Fishing expeditions in civil court are absolutely a thing. I'm insane. We're all insane. We're all mad here. It's like Alice in Wonderland. Proving petitioning is devoid of any reasonable factual support or any arguable basis in law is a difficult task. The anti-SLAPP law provides that if a court grants a special motion to dismiss, it shall award the moving party costs and reasonable attorney's fees. Hopefully he can get all his costs back, including those incurred for the special motion. The award of attorney's fees is mandatory. A denial of an anti-SLAPP motion is appealable under the doctrine of present execution. The doctrine of present execution. All right. Okay, Jeffrey Pyle, we see you. And is reviewed de novo. Fancy words. What page are we on? We're on page 12. Let's take a little break. Look at some super chats, and then we will come back. Okay, I flipped you. John Doe now says backpack with suit and tie post 30 does look silly. Okay, you're agreeing with me? All right, cool. LS says, I don't trust any mainstream media for news. The details are so often incorrect. YouTube or nothing. Miss Priss is here for 14 months. She says, I'm working toward the special cupcake. That's a 2-year cupcake. You're getting there, baby. You're getting there. Lily Line Media, I started this for later, said, whether anyone wants to admit it or not, AIDAN KEARNEY has done what many people don't have the nerve to do. He deserves credit when credit is due. Whether you like him or not, He exposed the cover-up. He did. He did. Stella Blue says, thanks for all the hard work you do for us behind the scenes. It's important that the public is aware of corruption, and here's the truth. I love you with all my heart. I love you so much, too. Carrie says, Melanie, is there any gray areas when it comes to Tully's NDA? Can Karen and Aidan's attorneys petition the courts to get the information from the NDA? Are you talking about the NDA that he signed with the feds to not talk about Proctor's text messages? I think that's what you're talking about, because Tully and Fanning were aware of Proctor's text messages back in February of 2024 when Proctor testified in front of the grand jury. If that's not what you're talking about, let me know. But Tully said in some recorded interview that he did for, I think, the IA investigation into Proctor, he said that he wasn't allowed to talk about the text messages because he signed an NDA with the feds. And so that's why Michael Proctor got glowing reviews and 5-star reviews from all of his supervisors, because they weren't allowed to talk about it. Because on the day that Michael Proctor testified in February 2024, Tully and Fanning went to Michael Proctor's house to do a wellness check on him. And without seeing the NDA, I can't opine on it because it depends on what the NDA says, which seems like, I understand why you want to know it, but I can't tell you my opinion unless I see the NDA. I mean, could they make a motion to the feds to try and release the information similar to like the TUI documents that came out in Karen Reed's criminal case? Yeah, maybe. And so, but without seeing the contents of the NDA, it's hard for me to opine, but I like the way you're thinking. Carrie. Thanks for your 10. Qbert is here. I was so good at that video game. I hate video game, but I really liked Qbert. They had it like in the local bar. Thanks for your 10. She says, Rita gave up years of her life to help with this case, but family, especially our aging moms, now take priority, as it does with many of us burnt out originals. Oh, love you, Qbert. Thanks for everything, Attorney Mel. I know. Listen, my generation is called, we're Gen X, the sandwich generation, because so many of us are taking care of parents and children. The sandwich generation. Thank you, Qbert, for your 10. You're sweet. Aunt Beebe's here. She's an OG. Thank you for your very generous 50. Says, in my opinion, I truly believe Officer John O'Keefe uncovered something powerful. Anyone close seems to hit a brick wall attempting to get justice. I pray the feds are watching and justice will finally prevail. Justice for OJO, number 2490. Thank you for everything you do, Mel. Proud to be a cupcake. Oh, Aunt Bibi, you were my first cupcake ever. You were my first member ever. I'll never forget it. This Monday is going to be the 3-year anniversary of this channel. That was 3 years ago that I did my first live stream on this channel. It was July 13th, 2023, and it was about Kevin Costner's divorce. We're going to be 3 on Monday. Yay, us. Thank you, Diane, for being here for 19 months and says, awesome. Melanie, 5 stars. Oh, thank you. Bridget says Caddyshack. Thank you for your 5. Yeah. Golf for a lot of people, who don't play golf, Caddyshack is, well, for people who do play golf too, Caddyshack is like the OG movie. It's the OG movie. Thank you, on top, for your super sticker. I appreciate you so much. Look at David Reese has been here for 25 months. He knows what's up. He's one of the minority of men who watch this channel. Robert P. Look, another one. Melanie, I love your show. It's both entertaining and informative. But on an unrelated note, watch the movie Dare to be Different about WLIR Long Island radio station. I think you'd enjoy it. I love WLIR. That was the greatest. It was 92.7, right? 92.7 WLIR. And I remember that their logo was like a seagull. Listen, kids, before YouTube music videos, and we listened to the radio. My first car was a 1966 fire engine red Mustang. Oh, did I love that car? Paid $2,500 for it, and I had an 8-track player in that car and a radio. It was amazing. Thank you, Robert, for your 10. And Classic Cupcake says she gets 5 memberships because she's amazing. I can't assume that you're a she, but she or he gifted a membership. Thank you so much. You're the greatest. This is like entertainment, but you also learn here. I try and make jokes. I try and be funny because if we don't laugh, we're going to cry. And you guys make me laugh. And I love that about you too. Joe King says, agree to disagree. Lawyer, undertakers, ice cream truck drivers all wear suits. It's true. It's true. Undertakers do. That's true. That is true. And ice cream truck drivers. Yeah, I guess the good humor man wears like a little bow tie. Listen, I'm very upset about the death of the suit and tie. I got to be honest. Very upset about it. What happened to the pocket square? I think I'm an old school when it comes to like dressing up. And I really wish that suit and ties would come back. You had the same, Julie, you had the same car. She says, my godfather gave me a red 1966 Mustang for my first car. Was it a hardtop? Mine was a hardtop. Loved that car so much. I loved it so much. All right, let's keep going. 1. Plaintiff's claims against Kearney are based solely on his petitioning activities. They are based on statements and acts that fall well within the broad ambit of the anti-SLAPP law protection for a party's exercise of his right of petition. Kearney is being sued solely for writing and speaking about the evidence in a pending criminal prosecution, rallying public opposition to the proceeding, reporting on facts that were likely to and did inspire public participation in the matter, and for arguing that authorities should charge the plaintiffs, not Karen Reed, with the underlying crime. All of that conduct is a protected petitioning activity. The definition of a party's exercise of its right of petition in the anti-SLAPP law is very broad. It includes several elements that squarely apply to Kearney's alleged speech and actions here, including any written or oral statement made in connection with an issue under consideration or review by a legislative, executive, or judicial body, any statement reasonably likely to encourage consideration or review of an issue by a legislative, executive, or judicial body, and any statement reasonably likely to enlist public participation in an effort to effect such consideration, and any other statement falling within constitutional protection of the right to petition government. In order to determine if statements are petitioning, courts consider them in the overall context in which they were made. Kearney's writings and statements constituted petitioning first and foremost because they were reasonably likely to enlist public participation concerning the O'Keefe killing and the Karen Reed prosecution. Kearney identified what he believed to be a massive travesty of justice, explained in detail the reasons for that conclusion, and inspired his hundreds of thousands of followers to take action to stop it, including by emailing and protesting against DA Morrissey and the police, protesting at the courthouse, and participating in public standouts against the prostitution, against the prosecution. My mind's in the gutter. Because there's some public prostitution scandals in Massachusetts too. And I love how they're quoting the amended complaint and agreeing with everything that they're saying. Look, hundreds of thousands of followers. That's their quote from the amended paragraph 143. Right on. Right on. They're like, yeah, you're right. The Supreme Judicial Court has squarely held that speech and advocacy designed to foment public participation around a pending judicial proceeding constitutes protected petitioning under the anti-SLAPP law. Okay, hold on a second. There's something I got to do. I can't control myself. Hold on a second. Okay, foment. We've seen that word foment. First of all, I had to make sure that I was pronouncing it right because it's not a word that I use ever, like ever. FOMENT. And I had to look up the definition. I mean, we can use our context clues to figure it out, but we've seen this word 10 times in the past 2 days. And I was this many years old when I first heard this word. It's not something I ever use in a legal pleading ever. So for you, all of you who are like, what does that mean? Foment is a verb that means to instigate, stir up, or encourage the development of something undesirable. Undesirable, though. It's not just promote or encourage. Yes, it's like instigate. It's like it has a negative connotation, such as trouble, violence, or discord. In a medical context, it can also mean applying heat and moisture like a warm compress to a part of the body to relieve pain or inflammation. Okay. Foment. It's got a negative connotation. It's like instigate. Okay, good. We see we learn things here too. Tina says the same thing. My first car was a 66 red Mustang hardtop. I bought off a neighbor for $2,500 in 1982. Then for some strange reason, I got the 5-speed 83 Mustang in 1983 the state troopers used in Florida. I love that for us. Weren't we so cool? Unfortunately, I banged mine up, so I don't still have it. I wish I did, but I don't. All right, foment is our word of the day. Today's stream is brought to you by the word foment. The SJC has squarely held that the speech and advocacy designed to foment public participation around a pending judicial proceeding constitutes protected petitioning under the Anti-Slapp law. In Cardno, 2 environmental activists published an article in the Huffington Post about a pollution lawsuit against BP arising from the Deepwater Horizon disaster. The activists wrote that an expert consultant for BP, Cardno Chemrisk, has a long and on at least one occasion fraudulent history of defending big polluters using questionable ethics to help their clients avoid legal responsibility for their actions. Cardno Chemrisk sued the activists for defamation, and the SJC held that the case had to be dismissed under the Anti-Slapp law. Okay, this is a case from 2017. The activist article the court held was protected petitioning activity because it was published to influence governmental bodies by increasing the amount and tenor of coverage around the environmental consequences of the spill, and included an implicit call for its readers to take action. Given this, the article fits squarely within the second clause of 59H, any statement reasonably likely to enlist public participation. Right? So here, Kearney's articles, videos, and actions plainly were intended to increase the amount and tenor of coverage around the Karen Read case. They also included implicit and explicit calls for the public to take action. In one of the earliest videos plaintiffs complain about, Kearney states that anyone who cares about John O'Keefe should be, quote, literally in front of the Massachusetts State Police headquarters or the Norfolk County DA's office every single day with a megaphone making noise, demanding to know how these incompetent law enforcement agents screwed this up so badly and why there aren't immediate resignations. And that was something that was cited in the amended complaint. And that is his April 22, 2023 video identified in the amended complaint. We watched it all because they cited it all. He repeatedly called the prosecution a harmful waste of time and resources and urged the authorities to prosecute the plaintiffs instead of Reed. Indeed, as plaintiffs acknowledged, Kearney's advocacy was not only reasonably likely to enlist public participation in the Reed case, it was wildly successful in doing so. Oh my gosh, I love this so much because he's owning it. He's owning all of it. He's like, you say I did this, you say I did that. Yeah, hell right I did. Hell yes I did. I did it all. And all of it is protected under Anti-Slapp. They thought they were disparaging him in their complaint and their amended complaint, and he's owning it just like you expected that he would. Pyle's a great writer too. I mean, this reads like a lot of legal pleadings that we read are so mumbo jumbo. They're like legal mumbo jumbo, and they're very confusing, and they're very word salady, and they're very, these a lot of big words. I mean, look, foment, I had to look it up, agreed. I don't know everything, and if I don't know something, I'll look it up. Never claimed to know everything, but it's written in a way that a layperson can understand it, and that's what I like about it. It reads like a story. And anybody could read this and understand exactly what it's like. But it's like butter. We have a butter emoji for that. We have a smooth as butter emoji. Check it out. We made that specifically for Alan Jackson. Smooth as butter emoji. Did everyone see David Uniti's picture on the cover of, oh, wait a second. Hold, please. On the cover of Boston College magazine? Hold on. I might have to. There's an article in Boston. Oh, wait. Sorry, StreamYard. If I go on the same browser, there's an article in Boston College magazine about the Karen Reed case, and this picture of David Uniti. Hold on. Our king, David Uniti, is on the cover of Boston College magazine because that's his alma mater. And I just want to let you enjoy this for a moment. There it is. He's so humble. He is so humble. Look at that picture. Come on. Come on. That's King David. Okay. He's like mid 60s. I forget how old he is exactly. I turned 60. I know he's a couple years older than me. I mean, come on. Is that amazing or what? And he was like, I'm so happy that I was on the cover of Boston College. Like, he's like the most humble, sweetest, amazing guy. He really is. Such a genuinely nice man. And I have gotten to know his sister Tanis from this case. She too is amazing. And I know because they've told me on streams and such that Mrs. Yannetti, Mama Yannetti watches my show too. She's a cupcake. Tanis is a cupcake. Tanis is my queen. Remember that day that Tanis went to court and argued in front of Judge Cannoni like a boss? Oh my God, I love that so much. Be a Yannetti. That is all. Okay, back to the papers. Just thought we'd take a little break to enjoy that lovely photograph. Okay, moving on. Okay. He was wildly successful in doing so. And here they're going to cite right back to them the amended complaint and say, yeah, all of this is true. Paragraph 60 to 63, alleging that Kearney assembled at least 200 individuals to participate in the rolling rally. Yes, I did. Paragraph 106, alleging that Kearney was the reason there were people outside the courthouse every single day chanting "Free Karen Reed" and wearing pink as a symbol of their support. Paragraph 121, alleging Kearney made it impossible for people not to know about the Karen Reed case. Yep. Further, the affidavit of Rita Lombardi shows that Kearney's statements convinced her, as a Canton resident, to co-sponsor a town meeting article to audit the Canton police. Rita was inspired by AIDAN. There is no purer example of public participation than a town meeting. Citing the Anti-Slapp law and a case from 1908, Wood versus the town of Milton, noting that a town meeting is a pure democracy where the citizens, as to matters within their jurisdiction, administer the affairs of the town in person. I think he's a briefcase. Yeah, David Uniti is absolutely 100% a briefcase slash satchel man. You wouldn't catch him with a backpacking course. Hell to the no. Kearney's statements also meet another element of the petitioning definition. They were made in connection with an issue under consideration or review by a judicial body. His statements were made to influence, inform, or at the very least, reach government bodies either directly or indirectly. They were closely and rationally related to the proceedings, and they were in furtherance of the objectives served by governmental consideration of the issue under review. Citing a whole bunch of cases, even licensing things in hospitals. The statements by Kearney identified in the amended complaint were made after Reed had been charged with murder. They related to the case. They were all in furtherance of the objectives of ensuring justice in the case and securing the indictment of one or more of the plaintiffs for O'Keefe's killing. And they were all made to influence or at least reach judicial and executive officials, either directly or through participation by other members of the public. As Kearney wrote on his website early on, the public advocacy campaign was intended to put public pressure on the DA's office and Judge Cannoni to remind them that there are millions of us watching their every move. We will not allow them to frame and prosecute an innocent woman for murder. Oops. while her killers remain free. We will continue to make our voices heard until there is real justice for John O'Keefe. Footnote 8, which reads, Kearney's words unintentionally echo those of Justice Oliver Wendell Holmes Jr. nearly 150 years ago. Oh, wow. Do you think AIDAN knew that? Chills. Quote, it is desirable that the trial of causes should take place under the public eye, because it is of the highest moment that those who administer justice should always act under the sense of public responsibility, and that every citizen should be able to satisfy himself with his own eyes as to the mode in which a public duty is performed. Print that. Print that, Judge Gildea, when you're talking about courts should not be a public spectacle. That is a quote from the case of Cowley v. Pulsifer in 1884. God bless America. In their amended complaint, plaintiffs allege that Kearney continued to make statements accusing plaintiffs of crimes related to the death of John O'Keefe after Reed was exonerated. These statements, too, meet the anti-Slapp law's definition of petitioning because of their continued likelihood of enlisting public participation and because they are reasonably likely to encourage consideration or review of an issue by an executive body. There's no statute of limitations for murder, and the O'Keefe killing remains within the six-year statute of limitations for manslaughter. Print that. Yeah, Allie, you remember when AJ said print that on the courthouse steps? Print that. I'm going to take it a step further, the way that Karen Reed did in her opposition and her motion, and tell you that because the O'Keefe's wrongful death suit overlapped with Karen's criminal cases and is still ongoing, there was not even a break in time that there was no public court cases going on in this case. Right? It's been ongoing. They filed that lawsuit in the summer of 2024 before trial number 2. And they're all still ongoing. So there's still more public participation needed. I'm going to say that again. There is no statute of limitations for murder, and the O'Keefe killing remains within the 6-year statute of limitations for manslaughter. Kearney's continued statements accusing the plaintiffs of having killed O'Keefe are thus reasonably likely to encourage the investigation or filing of charges against them. Indeed, in one of the videos plaintiffs identify as defamatory, Kearney states that he hoped the jury's unanimous acquittal of Reed would mean that all of us can unite and demand that the Alberts and the McCabes and Brian Higgins be held accountable for what they did to John O'Keefe. This is quintessential petitioning activity. You live in Norfolk County, get out there on September 1st. You might have to change your voter registration because I think it's a Democratic primary, right? Adam Deitch is running. He says he's going to reopen the case. And I guess whoever wins that primary is going to be the DA. So, it's kind of a one-party state, they tell me. September 1. Do it. AD for DA. AD for DA. Emily C. did a great interview with him. He also did an interview the other night with Christina Rex. It's very telling. He tells us everything. He's not done. He's so outraged by this that he moved to Norfolk County to run. In a vain attempt to distract from this conclusion, plaintiffs allege that Kearney had a commercial motive and a profit model behind his statements. However, the motive behind the petitioning activity is irrelevant at this initial stage of the anti-Slapp test. Instead, the focus is solely on the conduct complained of, citing lots of cases. In fact, as the SJC has recently reemphasized, a party may seek to invoke the powerful protections of the Anti-Slapp statute to protect speech, even if it involves a commercial motive, with only a limited relationship to issues of public concern. As such, allegations about Kearney's profit motive are irrelevant, right? They just want everyone to know how much money he makes. Guess what? He's spent it all on attorney's fees. So are you happy now? Footnote 9, which reads, nor does Kearney's use of name calling render his statements unprotected by the very broad definition of petitioning. Complaining, in the amended complaint, complaining that Kearney referred to plaintiff McCabe as a horse face, a Disney villain, and a pig. Here's the Afro Man effect. We have a cupcake for that. Boy, if you wanted everyone talking about you, filing this lawsuit sure did it. Article 19 expressly envisions a politically active and engaged, even aggrieved and angry populace. Although civility can and should be encouraged in political discourse, it cannot be required. In this country, we have never concluded that there is a compelling need to mandate that political discourse with those with whom we strongly disagree be courteous and respectful. Rather, we have concluded that political speech must remain uninhibited, robust, and wide open. That's a 2023 case. And then they go on to talk about another case. Anti-Slapp protected a website operator who called the plaintiff a retired state trooper and member of the, I don't know how to pronounce this, ATHOL, A-T-H-O-L, Athol, I don't know, Board of Selectmen, a Nazi. Oh, that seems to be on point. Holding the anti-Slapp law protected satiric website's definition of Nazi to mean in ATHOL, a term sometimes used to describe certain selectmen who wish to ignore most issues except for those which place them firmly in bed with chiefs at police. See, Old MacDonald had a gun, E-I-E-I-O shit. Okay, tell us more, Athol. Okay, Athol. Athol. Thank you, Mitchell. Roman 2, none of the plaintiffs' claims against Kearney has any substantial basis other than petitioning activity. Athol. Although plaintiffs make a number of spurious and irrelevant allegations about Kearney's motives, the actual conduct complained of in each of their counts against him is petitioning alone. As shown below, there's no substantial basis to any of these claims other than or in addition to Kearney's petitioning activities. The first claim against Kearney for defamation, count 2, is based entirely on his allegedly defamatory statements that the plaintiffs, quote, were responsible for the murder of O'Keefe and a cover-up of their purported role in that murder. As shown above, these statements constituted the exercise of Kearney's right to petition because they were reasonably likely to, and did, enlist public participation in putting pressure on prosecutors to drop the case against Reed and charge the plaintiffs instead, and were made in connection with an issue under consideration by a judicial body. The overall context in which they were made, moreover, shows that they were intended to ensure justice in the case and bring about the prosecution of the plaintiffs. Accordingly, the defamation claim is based on petitioning alone. Funny comment about dumb ones. The Mika says, those are fairly accurate. I definitely see most of them as Disney villains, but like dumb ones. The evil stepsisters, if you will. Ethel is very Scottish. Did I tell you that I'm watching Outlander and I'm addicted? I love it so much. Thank you, Sam. In their count of civil conspiracy, plaintiffs allege that Kearney and Reed agreed to defame the plaintiffs and inflict emotional distress on them by publishing information suggesting that Reed was innocent and that the plaintiffs were guilty, an agreement carried out by Reed funneling information to Kearney for publication. In other words, plaintiffs allege that defendants conspired to publish statements implicating the plaintiffs in the killing. As explained above, such statements were reasonably likely to enlist public participation around the case and to encourage authorities to bring charges against the plaintiffs. This count thus targets petitioning activity alone. He's like, yeah, I said it. I said it because I wanted people to pay attention because I think it's true. And I think everyone needs to know it's Sassenach. Thank you. You can't make this up, 38. Sassenach. Plaintiffs' emotional distress counts, 5 and 8, essentially duplicate their defamation claim. In both counts, plaintiffs complain of Kearney's acts of publishing statements accusing plaintiffs of crimes, acts that can constitute petitioning activity, as explained above. For example, in your complaint, count 5, Kearney broadcasted his campaign of outrageous and false statements about the plaintiff. Yep. Count 8, Kearney's campaign of outrageous, cruel, and malicious lies created an unreasonable risk of causing the plaintiff severe emotional distress. Where a defamation count is based solely on petitioning, the same must be true of emotional distress claims based on the same statements. Citing some case law. Plaintiffs cannot avoid this conclusion by pointing to their allegations that Kearney engaged in extreme and outrageous conduct, because even cursory scrutiny of those allegations show that they identify only petitioning. Citing some more case law. For example, plaintiffs complain that Kearney accosted McCabe at a sporting event and recorded this interaction on camera to publish on his communication platforms, right? That's the lacrosse game, right? Bill Ricca, I think. See, I know how to pronounce Bill Ricca. I also know how to pronounce Kieran. Kieran. The video of the encounter shows that Kearney sought to ask McCabe questions about her actions on the night in question. Footnote 11. Which reads, embedded video of Kearney's effort to ask McCabe questions can be seen here. Oh, good. Good. And article about Kearney's attempt to ask Jennifer McCabe why she Googled how long to die in cold at 2:27 a.m. on the night in question. Yeah. And the lacrosse game when Jen laughed at being asked if she killed O'Keefe. Pat Ray says, Letteros by Bettero. Good to see you too. She says, damn, Pyle's worth every penny. Also pointing out that I love how Pyle has embraced Turtleboy's position in his journalism. Yeah, he is owning it. Owning it. Thank you, Tina, for pointing out that unlike the Commonwealth, I do know how to pronounce Kearney. I do. It's not hard. Just think like carnival, Kearney. Kearney published the resulting video in furtherance of his quest to show Karen Reed's innocence, and publication of McCabe's reaction to his questions was likely to spur public interest and participation. That was all the way back in June of 2023 when many of us, including myself, had no idea who Karen Reed was. So if you're local and you remember that being published in June 6/6/23, let me know if you saw it when it first hit his website. Be interested to know. If you saw that video when it first came out in June of 2023, just put a 1 in the chat. We lost Bobby Weir 6 months ago today. I'm still sad about it. I still cry about it. I'm so sorry, Stella Blue. I know it hurts my soul. I try not to think about it because it really hurts me. That's why I say buy the tickets. Rest in peace, Bob Weir. Thus, the confrontation amounted to petitioning as broadly defined in the General Law 59H. Many of you saw it. Okay, not a lot of you, but 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Many of you are OG, Turtleboy OGs. Similarly, plaintiffs allege that in one of his videos, Kearney displayed an image of a police incident report that had been publicly filed in court containing some of plaintiffs' social security numbers and addresses. Yes, that's a big part of their motion. A big part of it. Footnote 12. As the video shows, Kearney did not highlight or even mention the social security numbers or addresses in this video. He merely displayed the publicly filed report while discussing other content within it. Here it is, a link to Rumble. In that same video, Kearney expressly exhorts people who care about John O'Keefe to demand justice and immediate resignations in the Massachusetts State Police and Norfolk County District Attorney's Office over the case. Likewise, the amended complaint alleged that Kearney engaged in extreme and outrageous conduct by leading peaceful protesters in cars through public streets of Canton in a rolling rally to bring awareness to the case, a rally that ended in a protest in front of the Canton PD. As Kearney stated at the time, the rolling rally came in the context of his effort to put public pressure on the DA's office and Judge Cannoni not to frame and prosecute an innocent woman for murder while her killers remain free. Quintessential petitioning conduct. Such an assembly plainly could be expected to foment further public participation. Also worth pointing out is that Canton PD and the MSP were both on notice that this was happening. They set up cameras to record this rolling rally, and they could have been out watching what was happening, but they chose not to, I believe, right? Footnote 13, which says, in their amended complaint, plaintiffs newly allege that Kearney's speech was intended to intimidate plaintiffs to not testify to change their testimony. Plaintiffs identify no facts supporting this baseless allegation. However, once again, the court's task is not to speculate on Kearney's motives for petitioning, but to determine whether the specific allegedly actionable statements and conduct meet the definition of petitioning set forth in the statute. Plaintiffs vaguely complain of harassing voicemails, but they identify only a single voicemail that Kearney allegedly left for Boston police officer Brian Albert. Thanks, Jenny. During the same April 22nd, 2023 live stream video discussed above, asking him, and this was a voicemail to Brian Albert, did you kill John O'Keefe or was it your nephew Colin? And are you covering for him? How did your dog get downstairs and begin biting Mr. O'Keefe? These questions are plainly geared toward advancing Kearney's cause of eliciting information that could ensure justice in the case, and they came in the context of an express call to petition the government. Footnote 14, which reads, plaintiffs also complain of Kearney's name calling, which is both non-actionable and petitioning, as explained above. Finally, they assert that Kearney encouraged his followers to harass and confront plaintiffs, but this conclusory allegation is wholly unsupported by facts. Such a threadbare assertion does not show a meritorious claim with a substantial basis other than, or in addition to, the petitioning activities implicated. And trust me, if they had other harassing voicemails, they would have definitely pointed them out in their amended complaint, because their amended complaint specified a lot more things. For the sole purpose of trying to overcome the anti-Slapp motion that they knew was going to come. Okay? Because they made the same motion in federal court that in the case that Karen Reed brought against everybody. Finally, in count 11, plaintiffs attempt to recast their defamation claim as one for a violation of the Consumer Protection Act. But once again, the only basis for the count is Kearney's publication of the blog posts, videos, and other statements identified above, allegedly with a commercial motive. As explained above, the allegation of a commercial motive does not show a substantial basis to a claim other than or in addition to petitioning. I thought that was like a very creative, novel argument. I don't think it's going to survive, but based on the fact that Judge Gildea is going to be the one deciding this motion, I guess anything goes. I mean, he already thinks that AIDAN Kearney leaked impounded information. with his tweet that we know was published at 10:52 a.m. and that we know 2 days before he received information from a source about where Michael Proctor was. But the judge has already told everybody by calling all those attorneys into court very publicly and making them all swear that they had nothing to do with it. And now we find out that that was Aidan's tweet. How can he be impartial with anything having to do with Aidan Kearney? It's a rhetorical question, but will anything happen? I don't know. Is it going to cost Aidan Kearney hella lot more money to make a motion to accuse and everything else and to jump through all of those hoops? Yeah. That's why we've pinned his give, send, go at the bottom of your chat. If you're on your phone, if you can afford, please contribute to his defense fund. Because not only is he facing 90-something years in prison on the criminal witness intimidation charges, which are bogus in my opinion, he's also paying lawyers to defend this piece of nonsense, defamation claims. Roman 3, Kearney's petitioning activity was not devoid of any reasonable factual support or arguable basis in law. As explained above, each count of the amended complaint is based solely on Kearney's petitioning activity, so the burden now shifts to the plaintiffs to show that Kearney's exercise of his right of petition was devoid of any reasonable factual support or any arguable basis in law and caused actual injury to the special motion opponent. I mean, how far do we even need to go in this analysis, you and I? Because you know, and I know, if you've been watching all the seasons of this debacle, season 1, season 2, trial 1, trial 2, pretrial season 1, pretrial 2, season 2, post-trial season 2, you know that a reasonable person could believe, based on just looking at their testimony alone and their witness statements and the public filings and the court documents, that their own testimony, that their own actions would make many people believe that they had something to do with this. You were not all brainwashed by Turtleboy. I know that. You're not all brainwashed by me and other law tubers that you watch. You make up your own minds. Nobody tells you what to do. And so ask yourself, the things that Aidan said, are they devoid, completely absent of any reasonable factual support? Clarion call, that's right. Turtleboy was the Clarion call. Thank you, Patty. You're all independent thinkers. You have excellent critical thinking skills. Hello, Rathouse Media. Good to see you. Emily Baker definitely wasn't influenced by Turtleboy, and her head pops off too. I mean, she doesn't say that her head pops off, but I've seen the way she reacts to this. Thanks to Next Witness and some amazing compilation videos. Oh, here's an excellent quote from a case from 2019. Proving that the moving party's petitioning activity was, in essence, a sham presents a high bar. Oh, it's a high bar. The SJC's jurisprudence has tended to equate the standard under the anti-Slapp statute with the concept of frivolousness. A claim is frivolous if there is an absence of legal or factual basis for the claim, and if the claim is without even a colorable basis of law. Love the way this man writes. Moving on. Importantly, plaintiffs cannot prevail merely by submitting affidavits controverting the statements made in Kearney's petitioning and in the affidavits supporting his special motion to dismiss, right? They all said, we had nothing to do with the death of John O'Keefe. We read those affidavits or declarations, they called them declarations, in opposition to Karen Reed's motion, which we went over yesterday. And I assume that the declarations are going to be the same in opposition to Aidan Kearney's motion. Material disputed credibility issues may not be resolved in the plaintiff's favor in ruling on the presence of reasonable factual support, nor can plaintiffs satisfy their burden by challenging the accuracy of isolated statements in Kearney's various blog posts and YouTube shows. The question is not whether each and every assertion made in the course of petitioning activity has reasonable factual support, but whether the special motion's proponents' exercise of its right to petition itself was devoid of any reasonable factual support. Citing some more cases. Here, Kearney's petitioning activity, or Kearney's petitioning, primarily concerned what he viewed as the unjust prosecution of Karen Reed and the MSP's wrongful failure to investigate the plaintiffs, despite evidence suggesting Reed did not strike O'Keefe with her vehicle and that plaintiffs were responsible for his death and its subsequent cover-up. Plaintiffs cannot show that Kearney's statements, whether directed at Karen Reed's innocence or their own culpability, were devoid of any reasonable factual support or arguable legal basis. Kearney's petitioning concerning Karen Reed's innocence is supported by the facts and the law. Sworn testimony from expert and percipient witnesses on the law. Indeed, at the conclusion of Reed's first trial, the jury failed to reach a unanimous verdict, and the court declared a mistrial. In the second trial, the jury acquitted Reed on all counts related to Officer O'Keefe's death, second-degree murder, manslaughter while operating a motor vehicle under the influence, and leaving the scene of an accident, resulting in death. The jury's determination forecloses any claim that Kearney's statements regarding her innocence were devoid of any reasonable factual support or arguable basis in law. That's a great argument. She was acquitted. She was acquitted. And so therefore, everything that I was saying then and continue to say now has a reasonable basis in fact, because still no one has been convicted of or even suspected of the murder of John O'Keefe because of such a horrific police investigation. And look what's happening to all of the investigators. One by one, the dominoes are falling. Michael Proctor, Sean Good. Everybody's rehoming themselves, retiring, making sure they get their pension. Some of them have received promotions. Many of them did receive promotions. Look how many fled the Norfolk District Attorney's Office in flames. Lynn Beeland, David Traub. Tick, tick, boom. You kept said 5640. Tick, tick, boom. If there was no car accident, which we know there wasn't, something else happened to John O'Keefe. Retirement is underrated. Yes, Scott. I'm just saying, somebody needs to figure out what happened here. Untwist the pretzel, yeah. Moving on. Here. It is not enough for the plaintiff to show, in this case, Jennifer McCabe, Colin and Brian Albert and Brian Higgins. It is not enough for them to show that the defendant's alleged petitioning activity was based on an error of law. He must show that no reasonable person could conclude that there was a basis in law for his position. You're all reasonable people. There is, moreover, extensive factual support for the jury's acquittal of Reed and Kearney's statements concerning her innocence. As Kearney repeatedly explained, Reed could not have caused O'Keefe's injuries by striking him with her vehicle. Sorry, I thought I was muted. Rather, the evidence at trial pointed to a physical altercation. Kearney's statements that O'Keefe's injuries could not have been caused by Reed's vehicle are supported by extensive expert testimony, including but not limited to the following. Here we go. Dr. Irene Scorti-Bello, the medical examiner, assigned to examine O'Keefe and a prosecution witness, testified that other than the wounds on his right arm, O'Keefe did not sustain any significant injuries below the neck. I've been screaming about this since I first started talking about this case. And they attached Dr. Irene Squirty-Bellows' transcript and then footnote it. Dr. Squirty-Bellow also testified that while she could not determine what caused the wounds on O'Keefe's right arm, the wounds were the result of blunt force trauma, and animal claws can cause blunt force trauma. Dr. Elizabeth LaPosada, the former chief medical examiner for Rhode Island and a professor at Brown University, testified that in her opinion, O'Keefe died from a massive skull fracture that was not consistent with a vehicle strike. She further testified that due to the abrasions on the back of O'Keefe's head, the injury was most likely caused by falling backward onto something that had a little ridge, and that she saw no evidence of any such ridge surface at the location of O'Keefe's body was found. Dr. LaPosada also testified that she saw no signs of hypothermia in O'Keefe's body and that wounds on his right arm were consistent with an animal bite or claw marks. Dr. Andrew Rentschler, Crash Daddy #1, a biomechanical engineer and accident reconstructionist originally retained by the federal government, testified that O'Keefe's injuries were not consistent with a vehicle strike. Rentschler said, and they quote, "We have no information that he was even hit by the Lexus." Dr. Daniel Wolf, Crash Daddy #2, was an accident reconstructionist who also was originally retained by the federal government as part of its investigation, testified that based on extensive testing he performed using a crash test dummy, the damage to Reed's vehicle was not consistent with striking a pedestrian. Testimony from percipient witnesses provides additional factual support for Kearney's petitioning, and specifically his assertions that Reed did not strike O'Keefe with her vehicle. For example, Brian Loughran, aka Lucky, who plowed Fairview Road on the morning of January 29th, testified that on his first pass by the Albert residence at approximately 2:45 a.m., 2 hours after the Commonwealth claimed that Reed struck O'Keefe, he saw no body or anything else near the flagpole where O'Keefe was later found. On his second pass at approximately 3:15 to 3:30 a.m., a Ford Edge was parked in front of the flagpole, but the yard to its right was visible, and he observed nothing on the ground where O'Keefe's body was subsequently discovered. Loughran was surprised to see a vehicle on the street because the Alberts never parked on the street. Remember also, Lucky grew up with the Alberts, and so he knew them since he was a kid, and he didn't want to get them in trouble for parking on the street during a nor'easter or an upcoming nor'easter because they would get a ticket, so he didn't report them. I remember. In both trials, the Commonwealth relied on taillight pieces allegedly found at 34 Fairview Road and a photograph depicting extensive damage to the right rear taillight of Reed's vehicle. Sergeant Nick Barros of the Dighton PD, however, testified that he was present when law enforcement took possession of Reed's vehicle at her parents' Dighton residence on the evening of January 29th, and the taillight was not completely damaged. When presented with the Commonwealth's photograph of the taillight during the second trial and asked whether it was consistent with what he observed on January 29th, Sergeant Barros testified, absolutely not. Absolutely not. When Barros observed the taillight on January 29th, the middle part of the taillight was intact, and only this side had a missing piece. It was not completely smashed out as depicted on the photo. Barros, one of the good guys. One of the good guys. Let me just star some of these comments for later. Okay. Kearney's petitioning about plaintiff's culpability as it relates to the competency of the Canton Police Department and the adequacy of the state police investigation is supported by facts and law. The other focus of Kearney's petitioning was the integrity of the investigation of O'Keefe's death by the MSP and Canton PD, including their failure to investigate whether plaintiffs were responsible for the killing. As with Kearney's petitioning about Reed's innocence, His petitioning about plaintiff's responsibility for O'Keefe's death is not devoid of reasonable factual support or arguable legal basis. As a threshold matter, O'Keefe's body was found on Brian Albert's property at 34 Fairview Road, where each of the plaintiffs had been drinking into the early morning hours of January 29th. If Reed did not cause O'Keefe's injuries by striking him with her vehicle, and as set forth above, there is substantial evidence that she did not. Someone else caused his fatal injuries, and it is reasonable to infer that those present at the Albert home that evening were responsible, particularly given expert testimony that O'Keefe's injuries are inconsistent with being struck by a car. There's also evidence from which a reasonable person could infer that each of the plaintiffs had a role in causing O'Keefe's injuries or participating in a cover-up to conceal the true cause of O'Keefe's death. Okay, here's the Afro Man effect. Let's hear it. What I love about this motion is that it is so much more fact-based than law-based. I mean, the law is in there and there's a lot of cases cited, but he's giving us like all the tea and all the reasons why he said what he said and all the reasons why a reasonable person would believe that they were involved. Here's the Afro Man cupcake. This is the Afro Man effect. Thank you, Charissa, for making this. Swipe or no swiping. I haven't done that in a long time. Remember before I said that I've got this like trackpad. See this thing? And just did it again. It's like a trackpad. And if I'm like moving the mouse around and trying to get over to something and I swipe left, it swipes me right out of the damn stream. Happens sometimes. Hasn't happened in a long time, but sometimes it happens. All right. So now we got to go back, pull everything up again. Okay. Back to Jennifer McCabe. Here's what he say are the facts pointing that Jennifer McCabe had something to do with this. At 2:27 a.m. on January 29th, just a few hours before O'Keefe's body was discovered, McCabe Googled "Huss long to dying cold." And he's got receipts for all of it. McCabe admitted at trial that a forensic report of her phone data stated that the 2:27 a.m. search was later deleted. McCabe deleted other calls and screenshots on her phone on January 29th. Everything's got a citation to her trial transcript. While at 34 Fairview Road, shortly after O'Keefe's body was discovered on January 29th, McCabe told first responders that Reed said, "Could I have hit him?" Only later did McCabe testify that Reed said, "I hit him, I hit him, I hit him." In April of 2023, McCabe was approached by 2 FBI agents near her home in Canton. That was before Canton Cover-Up Part 1. McCabe initially falsely identified herself as her sister, Nicole. Remember, we read Jen McCabe's affidavit yesterday. All the reasons why she did that. She thought they were traveling salesmen. Minutes later, the FBI agents called McCabe, who said she needed 10 minutes before meeting with them. At the end of her meeting with the agents, they asked who, if anyone, she had spoken with between the time she falsely identified herself and the meeting. McCabe told agents that she had only spoken with her husband, Matt McCabe, and Carrie Roberts. Following the meeting, McCabe was told that lying to a federal agent is a crime, and she called the FBI agents and told them that in the minutes before her meeting with them, she had also called Brian Albert, among others, yes, Peggy O'Keefe, and her victim witness advocate. She says she just, in the 30 minutes, she just forgot. Brian Albert. As set forth above, the court allowed Reed to present evidence at trial related to Brian Albert as a third-party culprit. At the time of O'Keefe's death, Brian Albert was a Boston police officer and a trained boxer. Remember that? Those of you who watched, what's the name of that show? He was on a reality show called Boston's Finest. And I remember I found it on YouTube and I found an episode of him like wrapping up his hands with tape before he was going to get into the boxing ring. And I had to cut it out of my stream because they struck me on copyright for that. Many of you have seen that. He was in Boston's Finest as a badass. He was a trained boxer, and then Nicole tried to deny that on the stand. When O'Keefe, a fellow Boston police officer, was found dead on his front lawn on the morning of January 29th, Albert, a trained first responder, did not exit his home. Albert told Canton police that his daughter, Caitlin Albert, was only briefly in his home on January 29th and left around 12:15 a.m. Caitlin later told the Massachusetts State Police that she was actually the last to leave that evening around 2 a.m. Albert, MSP interview. That was in Caitlin Albert's MSP interview. At trial, Caitlin and her parents, Brian Albert and Nicole Albert, confirmed that she was the last to leave between 1:45 a.m. and 2 a.m. Albert also testified that he did not make any calls after all his guests left his house on January 29th, but call logs show a call between him and Brian Higgins at 2:22 a.m. on January 29th. According to Albert, that call was the result of a butt dial, and he could not have possibly held a telephone call because he was having intimate relations with his wife. That testimony is inconsistent with his wife's testimony that she went to bed shortly after the guests left. Was Boston Finest produced by Donnie Wahlberg? I did not know that. Thank you, James Lynch. On September 23rd, 2022, the Superior Court issued a preservation order to Brian Albert requiring that he preserve the contents of his cell phone. Okay, that was September 23rd, 2022, before AIDAN KEARNEY ever reported on this case. Ever. At trial, Brian Albert testified that on September 22nd, 2022, the day before the preservation order, he turned in his cell phone and purchased a new one. What do you think? You think somebody might have given him the heads up? Oh, please. He did. I think he even got a whole new phone number and everything. Isn't it ironic? Don't you think? Right, Iron Horse. Oh, yeah. The cop who works for fugitive apprehension had no understanding of tracking cell phones. Yep. Yep. Chadwick says, following Melanie on reading Kearney updates is addictive. I can't stop. Sometimes I wonder if it's just too much content and like people are just going to get sick of it. And so sometimes I just take a break so that people can catch up on it. Because, you know, if I'm on the air for like 8 hours a day, it's like a lot for people. For viewers, it's a lot. Thank you for saying that. Three, Albert's dog, Chloe. At the time of O'Keefe's death, the Alberts owned a German Shepherd named Chloe, who was present at the home on the evening of January 28th. As Nicole and Brian Albert testified at trial, Chloe had a history of aggression. And in May of 2022, the dog injured a person who was trying to break up a fight between Chloe and another dog. Okay, so that was May of 2022. That was after the murder of John O'Keefe. Reed's dog bite expert, Dr. Marie Russell, testified that the wounds to O'Keefe's right arm were likely caused by a dog. Dr. LaPosada similarly testified that the wounds were consistent with animal bites or claw marks, and the medical examiner, Dr. Scorty Bello, testified that the wounds were caused by blunt force trauma and that a dog's claws can cause such trauma. Oh, that's so sweet, Sarah. She says, never. It's so sad when you're not here. Oh, that's so sweet. Lily Lime is a dog trainer. She's been bitten many times, and I've seen dog bites. Those were 100% dog bites on his arm. Shortly after O'Keefe's death, the Alberts rehomed Chloe, claiming that it was due to the incident in which she harmed a person more than 7 months prior to O'Keefe's death. Well, this was in May of 2022. The dog injured a person, but I think there was also an episode or a dog bite in 2021 also, right? And May of 2022 also lines up with the day that the autopsy photos of John O'Keefe's arm were finally released to the defense. We read that, I think, yesterday. Listen, you guys think you can't keep it straight? I can't keep it straight. There's so many cases to keep straight. And I have to remind myself that this is the case in which Karen Reed and Aidan Kearney are defendants, and they are defending their statements about the Alberts and the McCabes in the defamation case brought against them. Okay. Next, Brian Higgins. The court allowed Reed to present evidence at trial related to Higgins as a third-party culprit. The trial text messages were introduced establishing that Higgins had a romantic interest in Reed, and that on the night of January 28th, he expressed to Reed frustration at seeing her with O'Keefe. Yes, well, ... Despite admittedly drinking for most of January 28th and into the early morning hours of January 29th, Higgins did not drive straight home from Albert's home. He shouldn't have driven at all. Instead, in the middle of a snowstorm, he visited the Canton Police Department. Well, actually, it was like enough snow to track a cat. But the snowstorm was coming. Everyone knew it was impending. Just to correct the record. Tell me if you think he ever went home. He had an office at Canton PD. I think he stayed there. I don't think he ever went home, but he says he went home and he drank more and he ate some and then he butt-dialed Brian Albert back, or vice versa. At various times, Higgins gave different reasons for why he visited the Canton PD in the middle of a snowstorm. For example, he first told police he went to do administrative work. Then he told the grand jury that he went there to move cars around. Higgins testified he did not talk to anyone after leaving the Alberts' house and being notified of O'Keefe's death later in the morning of January 29th. However, telephone records established that he and Brian Albert had a 22-second phone call at 2:22 a.m. Oh my God. Hold on. I got the Angels number book right here. Okay. Here it is. Look. Angel numbers book. Okay. They had a 22-second phone call at 2:22 a.m. All right. We've looked up 227 before, but now we need to look up 222 because it's everywhere. Okay. It was in the papers the other day that Michael Proctor's attorney filed his impounded private medical information at 2:22. And now it's a 22-second phone call at 2:22. We need to find out what the Angels are telling us. Here it is, 2:22. Trust fall. Trust fall. That's what it says. Your angels ask you to trust your place in life right now. You're in the right place at the right time. Take a look around and enjoy the moment. Everything is where it's supposed to be. All right. Well, that's what it says right there in the angel numbers book. See if you can read it. I don't even know if it's in frame. See? Allie's here for angel numbers. But like it keeps coming up. So wait, let's also look up 22. This is me falling into a rabbit hole in real time. 22, believe. You are building the life you want. Your angels are in direct communication with you. This number is a powerful message that your life is being created with their divine assistance. You're in a space of high vibrational energy right now. Repeat this mantra. I believe in myself as we grow. Okay, that's 22. Can you see it? All right. And then just because we have to, because we're here, we're going to look up the number 2. Trust. You build your life with gratitude. It's not just the big things you can hope for. It's also the little things which keep everything together. You are never alone, and your angels are reminding you that so many small things together create a miraculous and cumulative outcome. Create a list of what you are grateful for today. This is John O'Keefe speaking to us in numbers, okay? There it is. You can call it hokey. I want to do another just, rando poll. If you did not become involved in paying attention to the Karen Reed debacle saga until after she was acquitted, if you're like new to this case, after trial 2, put a 1 in the chat. Yes, we went over these the other day, Dizzy. The new FOIA dump has Chloe's records. We went over them at length I forget what stream it was at this point. Chloe was first Cassidy and then was Cora. And then we found some posts where she was rehomed starting in May of 2022, and, you know, the whole thing and the trip to Vermont. There are some people in here who didn't even become involved, didn't even start listening to this stuff. Look at Minnesota Mom 723 until after the second trial. Jennifer Roberts. JK. Quinn. Skyview. ERF. And tell me, what are your thoughts on this? Mitchell, you weren't here until after trial 2? I didn't know that. Are you interested? Do you see how this turns into like the Afroman effect, where more people are now wanting to become invested in this because of the corruption? Thank you, Saucy Meat Sauce, too. Proctor doctored. Even changed her username. Gaining a whole new audience. John Pearson. Are you guys finding this content interesting? What does it do to your spidey senses? Aussie Jules, same. Canadian Bimbo is here. It says mid-second trial, I started looking for extra info because of all the shady testimony. Kitty says, my oldest didn't either, and now she's all in. Victory pointing out that 222 times 3 is 666. Those are the devil numbers. All right. If you're on replay, tell me in the comments. Like Brian Albert, Higgins was served with an order to preserve the contents of his cell phone on September 23rd, 2022. He testified that similar to Albert, he changed, oh, I'm sorry, it was Brian Higgins who changed his phone number. He changed phone carriers and phone numbers the day before. I mean, what are the odds that Brian Higgins and Brian Albert on the same exact day would both get new phones the day before September 23rd preservation? What are the odds? About 1 month later, in October 2023, Higgins disposed of his phone at a military base on Cape Cod. Wow, you can't make it up. He's like, I really don't remember if I did, but if I did, I might have cracked the SIM card and put it in 2 different dumpsters. You know, it was like the SIM card was, I mean, the military dumpster was on my way home, and, you know, I would get a discount on alcohol. I guess he's a veteran, and he was just like, no big whoop, no biggie. New phone, who dis? Right. His excuse was that, you know, like a confidential informant or somebody like a perpetrator found out his phone number, so he had to get a whole new phone number. Who does that? Who changes their phone number as a grown person? Okay, I've had the same cell phone number for like 25 years. Who does that? Nobody. Nobody. Is it consciousness of guilt? A lot of people think so. Next, Colin Albert. Colin Albert lived next door to O'Keefe. I thought it was like a couple of houses away, but okay. Colin Albert was at 34 Fairview on the evening of January 28th, celebrating his cousin Brian Albert Jr.'s birthday. I call him Beej. He claims to have left at 12:10 a.m. on January 29th. I love how this is so succinct and bullet pointed. At trial, Reed presented photographic evidence showing that on February 26, 2022, Colin Albert had scabbed knuckles. Yeah, he did. Colin claimed that he sustained the injuries to his knuckles when he slipped and fell and braced himself with his knuckles, right? He said he slipped and fell on a driveway because he didn't want to spill his beer. And, you know, he braced his fall with his knuckles. Anybody who's ever had a child who has fractured a wrist knows that when anybody falls, they put their hand out like this and typically would get a fractured wrist. Nobody braces their fall with their knuckles. We're smart. Evidence at trial also established that Colin Albert had a history of violent threats, including a video in which he threatened members of an area youth hockey team, right? Bang, bang. Pull up, bitch. In short, plaintiffs have no hope of demonstrating that Kearney's petitioning to establish Reed's innocence and plaintiff's culpability in the killing of John O'Keefe was devoid of reasonable factual or legal support. Accordingly, Kearney's anti-Slapp motion must be allowed. In addition to that, an award of reasonable attorney's fees and costs to Kearney is mandatory. The law says so. Once I win, once you dismiss this case, you got to give me my attorney's fees and costs. XOXO. For the foregoing reasons, Kearney respectfully requests the court allow his special motion to dismiss and that he be awarded his reasonable attorney's fees and costs incurred. XOXO. Aidan Kearney by Jeffrey Pyle. And this was served all the way back on the 18th of June, 2026. And as we know, there's going to be a hearing on this next Tuesday, the 14th. No, wait. Yes. Tuesday, July 14th, 10 a.m. There's going to be a hearing, which means we got to get to the opposition, some of the exhibits. I'd like to look at Rita's affidavit. I unfortunately, I have a colonoscopy scheduled for the morning of July 14th. Luckily, it's super early in the morning, of course. Will I be up and awake and out of anesthesia by 10 a.m.? I don't know. I hope so. You know me, I ain't gonna quit. Like, I've had babies on a Friday and been back like working on a Monday. Okay, that's just the way I roll. I'm just going to give you a fair warning right now. Let's go back to the chat. Because that's the way everything happens, you know. It just happens like that. Thank you, What in the Actual Fresh Hell, for coming in and throwing down a 5 and saying, thanks for Lady Melanie. I love you with all my heart. It's just a routine one. You know, you have to get colonoscopies just like you have to get your mammograms. Do it. Okay, just do it. Schedule it. Do it. Get her done. Classy Cupcake says, I'm a she, and I love your channel. Oh, thank you, sweet pea. B Michigan says, I've been here since the first Karen Reed persecution. Thanks for being here for 21 months. J. Michael says, thanks for the great site and insightful commentary. Thank you for being here for 24 months and for taking an interest and for being a nurse. And I stand with all of my nurses at Brigham and Women's Hospital today. Here's what happened. There's, I don't know how many thousands of nurses on strike outside Brigham and Women's. I don't know why that's a tongue twister for me. Hospital in Boston. They wanted to strike for one day, but what had happened was the hospital had to hire replacement nurses, scabs, if you will, to come in, and they had to be hired on a 5-day contract. So these nurses are now locked out of their jobs for 5 days. I stand with the nurses. They deserve every penny and then some. And love you, nurses. Jersey Queen says this morning Bus Stop Live was epic. I didn't see it. It was today. Okay. Thank you for telling me. I'll have to go back and watch it, Jersey Queen. Dina says, thank you for just being amazing. We love you, Dina. We love you so much. Cupcakes petitioning activity says, I'm ready. Let's go. Oh my gosh. Look at that. I love it. I love your little logo. It's like Cupcakes petitioning activity and it's adorable. I just want to check one thing here. Tell you one thing. Reminds me of the One Direction song, One Thing. You've got that. One thing. Hold on. Get up, get up, get up. Hold on. Come on. Where are my notifications? For the love of the traveling Mary. Hold on. Now I got to find this, and it's buried somewhere, but if it's happening tonight, I want you all to go watch it. I just need to look for it first. Is there a channel that's hosting a mod cruise tonight? Somebody sent it to me and I saw it somewhere. I don't know if it was tonight or a different night. Does anybody know? Because it's a channel that I'm not familiar with. And I know they're trying to raise money for a mod, for Edric Foss appeal. And that is one thing I will allow you to put in the chat. I don't know if it's tonight or when. Hold on. Because you know how much we love a mod cruise, right? Oh, wait. Okay, here it is. Hold, please. It's supposed to be tonight at what time? 7:30. Okay, so it's tonight at 7:30. If you want, maybe I could teleport you there if she's got it set up. All right. Thank you, Cupcakes, for petitioning. Cupcakes petitioning for activity. They're trying to hire Brian Steele for the appeal for Edric Foss, and it's going to take a lot of money. But he's going on there to talk about the trial, and it's called Florida Defense Team is the name of the channel. Blackbird Ear says, Mel, I've been cooking for teens with mental health struggles all day, and you reading to me in the background has made for some excellent food. Oh, I love that. Food is made with love. That's the most important ingredient is love, right? Satu said, Melanie, you're my source on news. You're also right about the disappearance of suits, professional me with backpacks and a lack of professionalism. I agree. Thank you, Satu, for being here for 23 months. And Coconut Cupcake says, I can't focus at work without Melanie's voice in my ear. Oh, I love that. I love it. Exactly. I don't know. Could I go live during the procedure? Some people would do that. There are channels that would do that. I'm not one of them. I'm not one of them. What I am right now is my voice. My voice is getting fried. Love is all you need. Hang on a second. I know a lot of people are working. A lot of people, I keep a lot of you company while you're working, and I love that so much for us. Hopefully you're being more productive instead of less, because then, and a lot of people are like, yeah, I'm at work. My boss doesn't mind because my boss watches you too. I'm like, oh my gosh, that's so awesome. I love it. I love it for all of us. All right. Thank you very much, because this is at the top of my inbox. So Diane gets credit for this only because it's at the top of my inbox. This is Gildea's decision on the motion for reconsideration on Proctor's stay of his deposition. Okay, so he typed a little thing on the front page of the motion because that's what they do sometimes. In fact, sometimes what they do, or Judge Cannoni used to do, is she used to scribble it. Judge Gildea has actually had someone type it in there for him. So let's take a look. We know that it was already denied, but let's take a look and see what his reasoning is for this. Here it is. The emergency motion that dropped at the very beginning of the stream has already been decided. As we knew, it was denied. Denied. Yeah, mammograms are a piece of cake. Literally, they take 5 minutes. No need to be scared. Like 5 minutes. It is so quick. Uh-oh. Emily said, strap your hat on tight because it's about to pop off. Okay, hold on. Let me see if I can make this bigger because it's very tiny font at the very, very bottom of this page. I'm here to help. This is, I guess this was decided or typed up after today's ridiculous hearing. Here you go. Judge Gildea says, July 10th, 2026, I've been presented with a motion for reconsideration of my order precluding further attempts to take discovery from a non-party, right, Michael Proctor, why doesn't he name him? Pending further orders of the court, an opposition and a reply. Well, we didn't see the opposition or the reply, but we saw that. Ms. Reed's attorneys are reminded of the provisions of Superior Court Rule 9A3 that a reply memorandum is to be limited to matters raised in the opposition, which were not and could not have been anticipated and addressed in the moving party's initial memorandum. There's so many things I want to say that I'm going to just keep a lid on for now. The motion misstates what I said. What I said was orders of the court have been violated either directly or at the very least in spirit. I did not say what is stated in the motion, quote, that an attorney with an appearance in this case had violated the letter or spirit of the rule. I also did not state on the record that I had stayed the second day of Proctor's deposition, but rather stated that because of the disclosure of sensitive private information, I temporarily stayed further discovery of the non-party. Okay, but you haven't lifted the stay. So how is that second part going to go ahead. See you next Tuesday. How's that going to happen? I acknowledge the information in the motion as to the time of a June 8th, 2026 post on X. Okay, so you're acknowledging it, that it was 10:52 a.m. However, such information does not allay the concerns that gave rise to the order, especially given the content of a June 25th, 2026 post on X. The motion for reconsideration is denied. Okay, what is the June 25th, 2026 post on X? I don't have time for all this gobbledygook, back and forth, bits and bytes bullshit, okay? Whose tweet is he referring to on January 25th of 2026? And if it's AIDAN KEARNEY, then 100% he should be recused from that case. That's it. You're done. You're done. We're done here. We're done here. We're done here. The motion for reconsideration is denied. Right. But are you lifting the stay? AIDAN posted about Proctor at his deposition. Oh, you mean like the panic attack? But was that pull up the opposition? It's in there. Oh boy. Just when I thought I was getting out of here. All right. Well, this is how we roll. This is how we roll. All plays. So this would be the opposition of Proctor's attorney. I have 400 emails in my inbox. I have 29,240 unread emails in my inbox. Thank you, Babe's mom, for buying me a matcha latte. I'm gonna need it. I don't know. The easiest way is for me to get it from the docket. So you know what? Listen to the Bang Bang song while I do that. I'm just going to trigger warn you on language. I'm going to go off the screen so that I can do this outside of your presence. Listen to the Bang Bang song and enjoy it. This is made by Varys.
Call this Bang Bang. Seriously? I will fuck you up. I will beat your ass. I will fuck you up. Pull up, bitch. I will fuck you up. I will beat your ass. I will fuck you up.
Objection. Objection.
I will fuck you up. KO. Bang bang. I will fuck you up. You're a bitch, bro. I will fuck you up. I will beat your ass. I will fuck you up. Right?
Yeah.
The bang bang, the bang bang, pull up. The bang bang, the bang bang, pull up. Right?
Yeah.
The bang bang, the bang bang, pull up. The bang bang, the bang bang, pull up.
All right, Mr. Lally, your next witness, please.
Yes, Your Honor, the Commonwealth will call Trooper Michael Proctor to the stand. State your name and spell your last name for the jury.
Michael Proctor, Proctor.
You're a bitch, bro. I will fuck you up. I will beat your ass. I will fuck you up.
I'm going to allow it.
the bang bang, the bang bang, pull up, the bang bang, the bang bang, pull up. Right?
Yeah.
The bang bang, the bang bang, pull up, the bang bang, the bang bang, pull up.
Yeah.
We ain't got no quit.
We ain't got no quit.
We ain't got no quit.
We are outraged.
We ain't got no quit.
We ain't got no quit.
We ain't got no quit.
We are outraged.
Oh shit. Bang bang. We ain't got no quit.
We ain't got no quit.
We ain't got no quit.
We are outraged.
Oh fucking hell. We ain't got no quit.
We ain't got no quit.
We ain't got no quit.
We are outraged.
I am outraged. That's me.
We ain't got no quit.
We ain't got no quit.
We ain't got no quit.
We are outraged.
We ain't got
Is that the first time that anybody's heard that? I changed the lighting behind me to red because, you know, it's Melanie After Dark now. You never know what could happen. You guys sure you want to keep going? You're not tired of me yet? If it's the first time you ever heard the Bang Bang song, put a 1 in the chat. It was made by an amazing guy named Varys. And I was in court. The only time I ever went to court for the Karen retrial was Flag Day, June 14th of 2024. And it was the day that Kelly Reed played the Bang Bang song for the first time for Alan Jackson, and he loved it. Loved it. Also, Terry Moorer and her documentary crew was like filming us eating lunch, and it was really kind of creepy. I got to be honest. It was weird. And I had a, you know, I had then, and I still have now, problem. They shouldn't have done it. They probably shouldn't have done it. All right, tell me why I can't open this opposition from Proctor. Come on, man. What kind of format did they put this in? All right, hold on again, because I got to go back, and I gotta convert it to a PDF, and it's like a whole damn thing. I have a Mac, doesn't really play well. Proctor's opposition. Let's see. 156.1. Okay, print, convert to PDF. Unfortunately, the one for Karen Reed is really only 6 pages, but it shows up as 36 pages. See if I can do it that way. It's always something. All right, so let's see what Proctor had to say in opposition to the motion to lift the stay, the emergency motion to force him to come in to be deposed. Okay? Because it never ends. It just never ends. I could do this 24 hours a day and never run out of things to talk about. I could literally do that. This is the case that keeps on giving. It never ends. It never ends. We're here, so we're going to look at it. Boy, I'm going to have a hell of a time timestamping this stream after it's over. Here we go. Earlier in the stream, when it first broke, we read Karen Reed's emergency motion to be able to depose Michael Proctor on Tuesday. See you next Tuesday. And here's Proctor's opposition to that, which was filed yesterday. But remember, nothing hits the docket until all of it is in the court's possession, apparently, because it just, you know, was sprung on us after today's conference. While I'm live, you're all on the yacht with me. Yacht today, Satan. Yacht today, Satan. Yeah, this goes on and on, my friend. All right, well, let me get my highlighter ready because, you know, it's a lot more reading. But we're going to do it. Non-party Michael Proctor's opposition to Karen Reed's emergency motion for reconsideration of an order delaying deposition of Michael Proctor. Now, I'm getting confused too. So didn't they at first make a motion to clarify And then the judge denied it and said, that's not the proper way to do it. You don't make a motion to clarify. You make a motion to reconsider, maybe. And I said, maybe a motion. So they make a motion for reconsider. And again, that's not good enough. Even though we went back and we watched the hearing again from like June 6th. And the judge said, you know, you can make a motion to clarify if you want, but we're not going to talk about it during the Zoom hearing. Again, Aidan's Defense Fund is pinned to the bottom of your chat if you're on a phone. Okay, here's what it says. Cognizant, Proctor's attorney says, cognizant of this court's admonishment to all counsel on July 1, 2026, and the Rule 3.6 of the Massachusetts Rules of Professional Conduct, Mr. Proctor will be brief. As in, like, Mr. Hamel's like, this is the attorney who looks like Abe Lincoln. And look, I'm sure he's a very, very, very nice guy. I have nothing against him. Look, lawyers are hired to do a job. He's doing his job. That's it. I'm sure he's a great lawyer. I'm sure he's a very nice man. He just kind of looked like Abraham Lincoln, in my opinion. Or like a character out of Hamilton. It's okay. But he's tossing the professional, you know, the ethical rule back at the judge because the judge did say that. That was a smart thing to do, actually. Just smash the like button. That would be very helpful. So it gets out there into the universe. As an initial matter, Ms. Reed's motion should be denied because it fails to even address the fact that information regarding Mr. Proctor's medical condition and his deposition was disseminated by AIDAN KEARNEY, aka Turtleboy, within 30 minutes of the conclusion of Mr. Proctor's June 25th, 2026 deposition. Tell us everything. Specifically on June 25th, 2026 at 5:30 p.m., Mr. Kearney posted on his X account, Dr. Turtleboy, as follows. Breaking news. Michael Proctor claimed to have a panic attack today and left his deposition. I have personally verified that he was seen outside being consoled by his lawyers who were asking him if he could continue. No word yet if he did. Oops. All right, I just highlighted everything. I didn't mean to. Okay, let's use our context clues and our spidey senses. And let's say that what happened was somebody out there, maybe an evildoer on the internet, somebody with nefarious intentions, decided to screenshot Aidan's tweet from June 8th morning in UTC time and send it to Proctor's attorney, Mr. Hamel, the same exact day of his deposition, okay? Which was June 25th. And we know that is when Proctor's attorney emailed the court with that June 8th tweet with the wrong timestamp on it, okay? We know that. Maybe it's an evildoer or somebody with nefarious intentions who really wants to help Michael Proctor get out of his deposition. Or really doesn't want Michael Proctor to testify for whatever nefarious reason. I don't know. And so when that didn't work, all of a sudden, Mr. Hamel now today, or this was filed yesterday, July 9th, now has the panic attack tweet. Okay. Follow the money. This information was accessed by a user with an X account. Okay. Footnote 1. Mr. Proctor acknowledges that the X account, that the X post referenced in Mr. Kearney's June 8th, 2026 post was accessed by a user with an X account. Okay. So wait a second. Somebody gave it to Proctor who has an X account. But again, they're going to be shady about where they got it. So Proctor somehow got it from someone with an X. Who's helping Proctor behind the scenes? Proctor saying he doesn't have an X account, so somebody gave it to him. And he acknowledges it. Okay. Is it sworn to? Because I don't play trust me, bro, with a guy like Proctor, who is a virulent bigot, racist, misogynist, and may have in fact planted some taillight. Okay. Are we just going to take his word for it? Okay, cool. Cool. A screenshot of the X post follows. Why Proctor's attorney, didn't you just go on X and get it yourself? So you can say, I accessed this myself. Because everything that you file should have, it carries more weight if you're telling the court this with your own personal knowledge as an officer of the court, instead of just throwing screenshots out there like you did the first time, which had an inaccurate timestamp on it. And here's the June 25th, 2026 post at 5:30 p.m. of Dr. Turtleboy. Breaking news, Michael Proctor claimed to have a panic attack today and left his deposition. I have personally verified that he was seen outside being consoled by his lawyers who were asking him if he could continue. No word yet, if he did. And then there's some replies here, one from, and it has 365.8 thousand views. Well, that's why they're trying to shut this down. It's got too big of a reach. Unfiltered Thoughts replied, post the pic. Aidan says, can't, unfortunately. Okay, so he didn't post the picture. In point of fact, Mr. Proctor did continue his deposition, and the deposition was suspended shortly after 5 p.m. Assuming arguendo that the X account did not default till 1:30 p.m. Eastern Standard Time, and given that this X post was accessed by a user with an X account, because Proctor said so, Mr. Kearney posted on X within 30 minutes of the conclusion of Mr. Proctor's deposition that Mr. Proctor claimed to have a panic attack and left his deposition. Okay. What time did he post this again? 5:30 p.m. Okay. So the attorney who was at the deposition with him is saying it ended at 5. This was posted at 5:30. So now again, you're telling us that it's true. Again, I wonder if whoever is communicating with AIDAN Kearney has nefarious intentions as well. Kate Peter has admitted that she is the one who spread the rumor about Colin Albert being a drug dealer. I'm going to say it again. She sent it to Aidan anonymously just to see if he would run with it. He did. She started it. She admitted it. She admitted it on a podcast somewhere, on a channel that I don't remember, that she thought it was funny, that she's the one who started the rumor about the drug dealer. So who? He says he's personally verified. Again, is it a bump? Are they trying to get Aidan in trouble by sending him this shit, knowing that he can't keep his mouth shut and that he's going to publish it? And now they're telling us it's true. Accordingly, the fact that Turtleboy posted, he's calling him Turtleboy instead of AIDAN Kearney, that Mr. Proctor left the deposition but had no word that he did continue the deposition, strongly implies that Turtleboy had this information while the deposition was ongoing. More importantly, the fact that Turtleboy posted that Mr. Proctor claimed to have a panic attack today and left his deposition implies that Turtleboy was aware of what was said during the confines of the deposition. Yeah, I don't think so. But note 2, which reads, as noted above, in response to another ex-user's request that Mr. Kearney post this pic, Mr. Kearney responded, can't, unfortunately. Oh yeah, I've said this before. And I'm going to say it again, Scorpio now, especially based on this newest filing. Do you think they should try and remove the judge? With regard to AIDAN Kearney, 100%, because he's already told us that he believes that AIDAN Kearney is violating his orders. I know Aidan shouldn't have to, but maybe he needs to be careful what he posts, as it can hurt all cases with him. Listen, you can be his attorney. If I was his attorney, I'd be kicking him under the table. I'd be telling him to shut the F up, but you can't control him. He's not controllable, okay? He's the client who you cannot control. This is how he makes his living. He makes his living by talking on the internet and writing articles for his website and exposing corruption. And again, they're going to use it against him. It's protected, but his attorney's fees are mounting and mounting and mounting. And that is why I have pinned Emily C's chat at the bottom of your chat if you're on your phone for his defense fund, because they want to put him in jail again. I mean, come on. To be clear, at no point has Mr. Proctor pointed the finger or otherwise accused any counselor party of disseminating impounded information. Mr. Proctor takes no position on that point. And again, they're just trying to shut AIDAN KEARNEY up, shut him down, bankrupt him, get him to stop, blogging about me, defame him, discredit him, bankrupt him, all the things. AIDAN is a journalist. He reports, says Katie Madison. This is the guy who wouldn't change a thing, having a breakdown because the truth is catching up to him, says Steve-O. And I guess Scott said it first, so full credit to both of you. See the rule of professional conduct, comment 3, prohibiting statements by counsel that the lawyer knows or should know will have a substantial likelihood of materially prejudicing an adjudicative proceeding. Given, however, the existence of the court's orders of impoundment and the sensitive nature of the impounded information, Mr. Proctor felt it appropriate to bring it to the court's attention that information which created a reasonable inference of a violation of the court's orders. As the court noted during the July 1, 2026 hearing, all parties and counsel certified to their lack of knowledge as to any facts regarding the potential dissemination of the impounded information. The judge is punishing Karen for AIDAN's journalism. Says Kristen Pino. Yeah, and there's no proof that any lawyer shared anything with AIDAN. Mr. Proctor's June 25th, 2026 deposition went forward for approximately 4 hours and 30 minutes with several agreed upon breaks. Mr. Proctor is a fact witness in this litigation and not a party. Despite having the opportunity to depose Mr. Proctor for hours, at no point did Ms. Reed's attorneys ask a single question regarding Mr. Proctor's investigation into John O'Keefe's death. Not a single question about Mr. Proctor's investigation into Ms. Reed's involvement in that death. Okay, so now you're telling us everything that was discussed at the deposition. I thought you wanted everything to be secret about Proctor's testimony. Instead, Ms. Reed's counsel spent much of the deposition questioning Mr. Proctor about various text messages that Reed's attorneys published in a recent lawsuit currently pending against the Canton PD and the Massachusetts State Police. None of these questions were relevant nor material to Mr. Proctor's investigation. Well, yeah, they go to bias. And you can be certain that the deposition was going to last longer than a half a day. And we know that because the second day of this deposition is supposed to be next Tuesday. And it sounds like another setup, says independent thinker, and I tend to agree with you. Nor were they relevant to the subject matter of this wrongful death action. Well, John O'Keefe wasn't hit by a car, so the whole wrongful death action rises or falls on whether or not they can prove that John O'Keefe was hit by a car. Such questioning can only be viewed as harassing in nature. Oh, poor Michael Proctor. Poor Michael Proctor is being harassed, and we need to put a stop to it. And you just told us everything that was talked about during the deposition. Accordingly, should the court allow Mr. Proctor's deposition to continue? Oh, should the court allow Mr. Proctor's deposition to continue? Mr. Proctor requests that the court limit it to 3.5 hours of deposition testimony. No, hell to the no. Karen Reed is entitled to defend herself against the false allegations of a car accident, and this is insane. I'm sorry, Jennifer Say. FYI, I'm in my feelings. My super chat was not read yesterday, but a reply to my super chat was read. Sweetheart, if you want to just email it to me, I'll take a look for it now. Did it come right as the stream ended? Because I might have signed off and it ended before that. And so I'm really sorry. But if you want to email me what it is that you said, or just put it right into the chat right now, I can look for it. I heartily apologize. I'm not perfect. And I thank you for your super chat. Sometimes they come in after I hit end on the stream and I don't see them. Finally, Mr. Proctor points out that on June 18th, 2026, counsel for Mr. Proctor requested from Ms. Reed's counsel assurances that neither you nor anyone on Reed's team will disseminate to any outside source including but not limited to media and or other social media platforms, any portion of the deposition, whether in video, audio, or transcript form. Well, you just did. You just told us everything. You just told us everything. Despite being the party that subpoenaed Mr. Proctor and the only party that questioned him on June 25th, Ms. Reed's counsel has continued to state that they will not provide such assurances. Regardless of whether the court allows Mr. Proctor's deposition to continue, Mr. Proctor respectfully requests that the court issue an order to Ms. Reed's counsel prohibiting them and anyone on Ms. Reed's team from disseminating to any outside source, including but not limited to media nor social media platforms, any portions of Mr. Proctor's deposition, whether in video, audio, or transcript. They're still trying to prove that Karen Reed and AIDAN Kearney are conspiring to leak information. Singing Fan said someone else posted the same panic attack tweet earlier that day. Oh, I love you too, Jennifer C. I love you. And I want to thank Jennifer C so much for her super chat yesterday. I don't know how much it is, but I'm sure it was very generous. And whatever you asked me, I love you so much. I'm happy to answer your questions. And if it was a compliment, I thank you for the compliment. If it was something mean, then I'm not gonna, I don't think it was anything mean. It happens. Sometimes they slip through the cracks. I'm sorry. So they want the court to issue an order about that. Okay. And then hold on, because there's more. There's a reply. Let me just get it over here. Take this down. And of course, by the time we see it, it's already ruled on, because that's the way they roll there. Show us the corruption continues. Without showing us the corruption continues. Why is Proctor being so protected? Follow the money. And we got to follow the money on this too. Here's the reply. And then the judge said in his order, you're not allowed to add stuff in your reply that you didn't add in your original motion. Yes, this is an exercise in gaslighting, says Victory. Wah, 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 poor Proctor. That is evil. This is that evil, malicious, racist monster who tried to ruin an innocent person's life. He's no victim. I know. Thank you, Beach Life, for donating to AIDAN. Yes, Jojo. They are openly accusing Karen's lawyers of this in a court filing. It seems that way. They're not even trying to hide their bias, Noni. You're right. Look at Quinn. She's like, how have you guys dealt with this through 2 damn trials already? I'm new here. And I'm thoroughly infuriated. And I'm still new here. That is why we continue to scream from the highest mountain. Forge every stream. Follow every rainbow. I just can't believe this is still happening. And they're still enabling it to happen. Here's the reply from Karen Reed. In her motion, Reed addressed the information the court referred to as the basis for the order. Reed asked the court to reconsider. The court entered that order because it concluded that impounded information had been shared with a non-party. As explained in Reed's motion, there's no evidence that that occurred. Thus, the order based on that conclusion should be vacated. As the court and Michael Proctor's counsel are aware, Reed has already specifically addressed the different ex post included in Proctor's opposition. Reed did so in Reed's letter to the court in response to Proctor first raising the issue. In a letter on June 26, as Reed explained in that letter, the post Proctor cites from AIDAN Kearney itself states Proctor was seen outside being consoled by his lawyers who were asking if he should continue. No word if he did. Okay. So Reed sent a letter on June 26. So we do know now that it was Proctor's attorney's letter to the court on the 25th, which was the same exact day as Michael Proctor's panic attack deposition. How many licks does it take to get to the center of a Tootsie Pop? How many excuses are they going to use to try and get Michael Proctor to not have to sit for his return deposition? Aidan posted the picture? When did he post the picture? I'm not publishing it. I'm not publishing it. Someone outside of the deposition saw him, and Mr. Kearney was unable to report whether or not the deposition concluded. This does not suggest in any way that someone in the deposition shared any information with anyone. In fact, it suggests the opposite. I don't want to publish it. I'm not publishing it. You can go look for it yourself if you want to see it. Proctor spent multiple hours outside the office where the deposition, because the next thing you know, I'm going to wind up in these court filings. You know who needs that? Nobody. Nobody. Proctor spent multiple hours outside of the office where the deposition took place, and presumably some time outside the office building. He's out there in the wild. Somebody got a picture of him. I don't know. Kearney's post explains that the information he shared made its way to him because Proctor and his counsel were observed in public. Other social media activity provides even more detail about how this information became public. Oh, Tara, tell us everything. Here's somebody called Dex. Looks like on the cesspool of Twitter, 25th of June, 2026, 11:29 a.m. He showed up and had a panic attack in the hall outside. And then Roxy McFly responded, prediction or fact? And then Dex says, I saw it with my own eyes on a security camera, but I cannot share it. Okay, there's Dex. There's Dex. Dex is the one. All of the available evidence suggests that the information in question came from someone unrelated to this case. Wouldn't it be crazy if that's a total troll account? The remainder of Proctor's opposition is essentially a motion for protective order, which Proctor has not filed and Reed has not had the opportunity to oppose. If Proctor serves or files such a motion, Reed will oppose it. That opposition will point out that 1, Proctor's description of Reed's counsel's questioning is inaccurate. 2, Reed's counsel extended Proctor the courtesy of delaying the start of the deposition for 2.5 hours to accommodate Proctor's stated needs and should not now be punished for that. As Proctor requests. I don't know what his needs were, but he's got a million reasons. Finally, Proctor's statement that Reed's counsel has continued to state that they will not provide assurances regarding the use of deposition transcripts and recordings is false. Reed's counsel has repeatedly and consistently, including in Rule 9C conversation yesterday with Proctor's counsel, stated that Reed will agree to the restrictions Proctor's counsel requested if all the parties to the case agree to them. Emails evidencing Reed's attempts to obtain all parties' agreements have been previously filed with the court. Plaintiffs have refused to respond to Reed's proposal, which mirrors Proctor's. Okay, so the O'Keefes are the ones. Wait, no, the plaintiffs. What case are we on again? Hold on. The O'Keefes. The O'Keefes have not agreed. The O'Keefes have not agreed. Plaintiff, O'Keefes, have refused to respond to Reed's proposal, which mirrors Proctor. Proctor's. Reed respectfully requests the court reconsider its order staying discovery from Proctor. XOXO. Karen Reed's attorneys. And then if you weren't here, because already there's a decision on this. Just got to, find it again. Judge said no. Judge denied it. And says they brought up new information in their reply. So there's that. What the actual flip? Here it is again. We're going to put up the decision because we got the decision before we got the other papers. He's got to be taken off this case. He can't decide anything with regard to Aidan Kearney because he's already shown his bias against Aidan Kearney by believing every random thing that is brought to his attention and calling it a violation of his order when there's no evidence that any lawyer leaked anything to him. He's got sources, okay? He's been doing this for a really long time. I don't know, 14 years or something by now. Here it is one more time. A little bit louder for those in the back. This is what Judge Gildea decided while we were on stream. This is what he said in response to the papers that we just read. Before I swipe myself out of here again, hold on. I have been presented with a motion for reconsideration. This is just today. I guess after the hearing, he did this. Of my order precluding further attempts to take discovery from a non-party pending further orders of the court in opposition and a reply. Ms. Reed's attorneys are reminded of the provisions of the Superior Court Rule 9A that a reply memorandum is to be limited to matters raised in the opposition, which were not and could not have been anticipated and addressed in the moving party's initial memorandum. Any chance that he gets to publicly spank Karen's attorneys, he takes it. And it seems like he enjoys it, kind of, in my opinion. The motion misstates what I said. What I said was, orders of the court have been violated either directly or at the very least in spirit, right? In spirit. And with his spirit. I did not say what is stated in the motion, quote, that an attorney with appearance in this case had violated the letter or spirit of the rule. I also did not state on the record that I had stayed the second day of Proctor's deposition, but rather stated that because of the disclosure of sensitive private information, I temporarily stayed further discovery of the non-party. Where isn't it the same thing? It's the same thing. I acknowledge the information in the motion as to the time of a June 8th, 2026 post on X. Okay, you're acknowledging the information, but do you believe it? Do you now admit? Are you now admitting on the record that you were wrong and that it wasn't at 2:52, that it was really at 10:52? You're acknowledging it. And that's like, you're kind of giving the thumbs up, okay? To the no nudes yet. The no nudes yet text from Michael Proctor. He just acknowledged it. He didn't really like it. He just acknowledged it. However, such information does not allay the concerns that give rise to the order, especially given the content of a June 25, 2026 post on X, right? That is the panic attack post that we just read. The same day as Michael Proctor's deposition, the motion for reconsideration is denied. Denied. You get nothing. Good day, sir. So what's going to happen with Michael Proctor's deposition on the 14th? Do we know? Well, I guess we should know, because I guess there's some sort of proposed order now, because God knows I can't get off this stream no matter how much I try, because the shit just keeps happening. Here it is. This is the judge's proposed discovery order. Thank you, Suzanne, for being at the top of my inbox with this. Let's see if he gives us any further guidance. Acknowledge the stream, please. Yes, thank you. On whether Michael Proctor's deposition will continue. Here it is. Proposed discovery order. I guess they didn't agree on anything. I don't remember when the deadline was now at this point. They were all supposed to agree on it. On July 1, 2026, I invited counsel to come to an agreement to hold private personal information in confidence. On July 6, 2026, I stated, let me just, hold on, make this a little bit bigger. That if no agreement is filed before 4:30 p.m. on July 9th, which was yesterday, I would issue further orders I deem appropriate. Prior to issuing any such order, I invite the parties to provide comments on the following draft language. Deposition testimony taken in this matter in the form of video or audio recordings or written transcripts, including private personal medical information learned at any such deposition or through discovery, shall not be disseminated and shall only be used for the purposes of this case. Or McCabe versus Reed et al. Oh, okay. So you're saying, that it's okay to use it in the wrongful death case of the O'Keefes versus Karen Reed and the defamation case of McCabe versus Reed. Okay. The defamation case and the car accident case, but they're not allowed to use it in the case of Karen Reed versus everybody in federal court. I don't think you're allowed to order that, Your Honor, because it is well known. It is Hornbook law that testimony under oath of any party can be used in any other case in which the party is placed under oath. Okay? That is why, this is so basic that it's insane. That is why the New York State Trial Lawyers Association has a database of all of the expert deposition transcripts, so that if you're hiring that expert, you can go into the New York State Trial Lawyers database, pull some or pay for, I don't know how they do it nowadays, but so that you can use experts' prior testimony against them in other trials. Come on, man. Right. Plus Karen Reed and MSP. Karen Reed versus MSP in Canton and Bristol County. How long? What's the over under? Are there odds in Vegas on this? How long is it going to be before that case is plucked out of Bristol County and given to Judge Gildea? How long? Each party is requested to provide written comments, 1 page and no more, to the above on or before 3 p.m. on Monday, July 13th, 2026. I really do think this is the only case this judge has. Does he have any other cases? Can anybody point me to any other cases that this judge has? Because God knows it's impossible for every single attorney in this case to work on any of their other cases. And as I told you before, every 6 minutes, they're sending out a bill. And if 5 lawyers are working on your case, you're getting a bill for 5 lawyers. If a paralegal is working on your case, you're getting a bill from the paralegal. I shudder to think of the bills that Karen Reed and AIDAN KEARNEY are going to get at the end of July. You're billed for every associate's time, every partner's time. Everyone's got a different billing rate. Paralegal's time. As to other pending actions, although the parties to any related matter are free to agree in such limitations, I will not enter an order in a matter not assigned to me. We really are in the upside down, inside out Narnia of Massachusetts, land of the lost. This is why we have a little logo for Chaka. Tony says, we have a long-standing culture of corruption and malfeasance. Corrupt politicians appoint judges, corrupt people manage the DA's office, corrupt people are appointed to management of the police forces. At this point, I'm running out of words for things to say to you. I'm running out of words for things to say, for ways to explain this to you. But now the world is watching. The world has been watching for a long time. And the insanity continues. My office staff have become free Karen Reed followers, says just a normal mom. She's been here for 20 months. Thank you. Cat Lady Ballerina says, Turtleboy said on 6/25 that Proctor was seen outside with lawyers. When the heck did outside get impounded? Again, he's telling us that he doesn't like what AIDAN KEARNEY's doing and he's trying to shut him up. AIDAN reported Proctor has a panic attack. Thank you, Andrea. Being here for 26 months. Craft Haskell says, thanks for staying to read the other documents, Melanie. We appreciate your time. Thank you. That was my favorite hold please ever, said just south of history with the bang bang. With the bang bang. Saucy Meat Sauce says, why being so cryptic? And to act like it's a burden to clarify these things when he's on everyone's back to get the case moving. Right. Oh, you're putting in a number 1 like you just got involved in this after trial too. See? This is the Afro-Man effect. Nurse Kim today had a great old acting video of Melanie. Oh, thank you. I don't know where people are finding that, but thanks. West Virginia Country says, this isn't the Zapruder film. Isn't it unethical for Proctor's attorney to argue favorably about the time with actually just verifying? Yeah. I know, but I don't want to get in trouble for because I don't want to be in the court papers. If you guys want to go see the picture of Michael Proctor, cowering in a squatted position outside the deposition, go on over to Aidan Kearney, Dr. Turtleboy's Twitter account, and you can see it for yourself. Next thing you know, they're going to be calling me out. And once again, for your linking pleasure, is Aidan Kearney's defense fund is linked at the bottom. And I'm also going to tell Aidan, if you see Aidan before I do on his stream, tell him to sell tickets to the dinner after the golf outing, and he will get a lot more traction on the dinner tickets because people want to come, but they're afraid. They don't want to play golf, whatever. Sell separate tickets for that. Every single golf outing does it. I'm sure you know. I don't know if you are, but I'm sure people would pay $100 just to come for dinner. The New Mexico Realtor says, wait until you see Gildea's response to the motion for reconsider. We just did. We saw it. I just don't even know what to say anymore at this point. I read it first, and then we went back and got the paper second. Thank you for your 10. Candy said Turtleboy's actual post at 4:30 before the deposition, and that's 5:30. Of course, it was wrong. Thanks, Candy. Mama bought. Well, I don't know what time zone you're in, but was he requesting protect a bigot in Canton Day? No, it's punch an N-word in Canton Day. Go get your retribution. Everybody, come on down. Jeannie, can Turtleboy submit a motion showing no lawyer involved and asked to have a protective order for his source, like the ACLU submitted something during Dep v. Heard? I don't think he cares. I don't think the judge cares. He doesn't care. But again, every single minute spent on this case by Aidan's lawyers is costing him 1/10 of an hour's billing by every single person who's working on it. Thank you, Tony, for your 5 super sticker. Josh said, I don't think someone's feeding Turtleboy anything to hem him up. He's reporting facts. Nothing he has reported is a lie. Hell, the court confirmed it. Yeah. But I think what I'm saying is people know that he is going to report it. And they think maybe they know that he could get in trouble for it. And so I don't know. I don't know the answer to it. I don't know if anybody's being nefarious or evil, but I think what's going on here is completely wrong. And I know that they're trying to shut him up, and I know that they're trying to incarcerate him. And I know it. I just know it. We've seen this film before, and we actually liked the ending for season 2, but now we're on season 3, and who knows what the hell is going to happen next. I don't know. I don't know. I don't know how to explain this to you anymore. I literally have no more words. Thank you, Nancy, for your very generous Venmo. She says, you work so hard for your money, girl. I love you with all my heart. Thank you. Thank you. And thanks for your matcha latte. Says, thanks for covering Aidan's case. I'm so glad you're on his side. I'm on the side of justice, for Christ's sake. And what's happening to him is wrong. It is selective persecution of an antiquated witness intimidation statute that says that you can prosecute someone if you hurt their feelings. And it's insane. I've never seen anything like it. Allison, thank you so much. And to everyone else who emailed me during the stream, I like my inbox. My inbox is so overwhelming, I'm just going to ignore it. Kyla, thank you for your Venmo. Says, thanks for all you do. You do it with such grace. Sometimes I have meltdowns. Okay. Bethany, I can't look up to see if you're blocked. I need the link to your channel, the physical link to your channel. Sending me an email with an email address doesn't do it. I need the link to your channel. Ask someone how to help you find it. You have to go to your channel on YouTube, even if you don't think you have one, you do. Copy and paste the link from your browser and then send it to me. I can't be going back and forth 20 times with people who have been blocked by YouTube, trying to get them to give me the right information. I just can't do it, and I won't. I don't have the time for it. Right now, the only thing I want to do is go eat dinner. I've been on the air since, I don't know, 2 o'clock, and it's already 8 o'clock. And with just a little teeny break. Hold on. Mom Bomb, wait, is Proctor now worried about the cameras? Apparently. Meep says, I'm flabbergasted. I thought things would change in the civil case, but it's the same. It's really almost like if you thought it couldn't get worse, you'd be wrong. Jennifer C says, what happens if Turtleboy does motion to accuse and is denied because same judge? Well, then they can appeal it. Everything costs money. And it's terrible. Thank you, Jennifer, for putting your another question in there. And V Kinds, we love you. You're doing great. Thank you. It's just, you know, it's frustrating. It's frustrating. Hold on one second. This is a travesty. Hang on. One moment. Hold on. Boop. I'm trying to redirect you over to a mod cruise because there's only 83 people watching. And that's a travesty. But this creator who I don't know does not have it set up so people can redirect. So I can't redirect you. So I'm just going to show it to you so that you can go over there, please, and find it yourself, because there's only 80 people watching now. And that's a travesty. So let me show this to you. And then I'm going to get off the air. And please go over and watch a mod cruise. Say hello for me. I want you to see this. Here's what it looks like. Ahmad Cruz live Edric Foss trial discussion Q&A after the verdict. This is on a channel called Florida Defense Team. I can't redirect you. There's only 78 people watching. Please go watch. Okay. I love you with all my heart. If I don't see you soon, I'm going to die. Make sure you have all of your notifications set and get on over there and watch Ahmad Cruz. Okay. I love you so much. I see you again very soon. Peace out.